Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our coverage of Washington versus Ali and Ali. We are into day 9. Closing arguments start today with jury instructions. And as the judge told us on Wednesday, because they were off Friday, but they did jury instructions on Thursday, they hammered it out, and we did stream that on Saturday. So if you guys want to check that out, please do so. But as the judge said, she's expecting for this to go to the jury on by the end of the day. So Northwest, yes, hello, how are you? And welcome to our 2 newest moderators, Aussie Gardner and Joanne Jedi Platypus. We went through some changes over the weekend, and we have brought on 2 new moderators to help us maintain a courteous, kind, and safe space for everybody. So please be kind to them. Laura Wright, good to see you. Thank you for joining us. Sherry M, back just in time. Good morning to you. Northwest, yep, the secret is out. The secret is out. Aussie is in blue. So is Joanne Jedi Platypus. Hey, LW350, good to see you. Thank you for joining us. And Pam E, Sharon Pierce saying hello. Fur Babies, congratulations, new mods. Wendy, thank you for joining us. Good to see you. Lynn in South Carolina, good to see you. Wendy's saying, I hope the jury gets it right. I think they will. I can't imagine. Well, the jury instructions were really complicated. You guys remember, if you guys were watching on Saturday. Hey, Sugar Beat and Agent 333. Tim Pace saying hello to everybody. Kathy Davis also saying hello. Kathy Davis saying good morning. Anita, welcome to the new moderators. Mallory, good to see you. Thank you for joining us. Hector's mom, good morning from Western Oregon. Thank you for joining us. MLC saying hello. Congratulations to the new mods. JPC as well. Angelique. Lily Wayne, Mama C. I think the dad will be found guilty. Not so sure about the mom. Yeah, I think we'll have time for some polls. We'll definitely do some polls, and that's going to be one of them. Hey, Fanny Pack, good to see you. Audrey Chance, good to see you. Thank you for joining us. Ruby, Shirley Roth, saying hello, hello. Tracy Burton, hello to you. Sarah Kardashian, good morning to you. Hey, Baca, good to see you. 13th juror, welcome in, welcome in. Welcome to our new mods. Please say hello while you come on in. Red Snap, welcome new mods. All right, so yeah, we'll do some polls today because we're going to have time, right? So we did, jury instructions were Thursday, and we streamed them on Saturday, and we went through, they went through, I think, 40, how many did they go through? What did they go through? Give me a second. 49, I believe. There were 49 instructions, 49 lines of instructions that they went through. Then they went through the verdict forms. And there was even at one point, I think it was the, what was it? Even the judge was having problems with the instructions, and even it was the WIPIC, right? The WPIC, they were having problems. Even the state was saying this language is really difficult. It might have been the assault. I forget right now. I'm trying to look through my notes quickly. They were having problems with the instructions. You know, even that was convoluted for them. So, but how was everybody's weekend? Today is closing arguments, absolutely. So we're going to have closing arguments. We're going to have jury instructions, and the judge even said that they think they're going to get to become what do you call it? Deliberation. Thank you. That's the word I'm looking for. All right, let me check in on the feed. Make sure I got the right one. Let me come over here. For those that are, they went through all those attempted second degree, attempted first degree kidnapping, second degree assault, fourth degree assault. That was Ihsan's charges. And then Zahra's charges, second degree M, first degree kidnapping, second degree assault, second degree burglary. And I think they were trying to get that fourth degree assault down to like third degree, or it was very confusing. I wasn't even quite sure what was happening. So I really just want to hear today. I want to hear these instructions. All right, let me get us over here. Let's see here. Let me get us over here and check out the feed. Make sure we got a good feed here for you guys.
Two parents face.
All right. See if they actually have a feed yet. So they do not have it up just yet, but we will be ready when it does come up for you guys. Tracy Burton saying hello to the new mods. Nan R, good to see you. Happy Hermit, hello new mod. Thank you guys for welcoming in our new mods. Deborah Owens, hello, hello. Skybell, we're going to be in verdict watch today. It seems like it. That's what the judge was saying on Wednesday. She thinks that they could get to that point. It's going to be probably around 3 or 4. So 3 or 4 their time. So it'd be 6, 7 o'clock our time. So they only go to 4:30. So if they do, it's going to be maybe pick a 4 person, and that's about it. Bridget says, I think the dad will be guilty, but I'm unsure of the top charges for mom. To me, they seem thin. Do you have a thought? I think so as well. I think they proved it for me, absolutely. For dad, I was going to say Ali, Mr. Ali. But mom's a little bit thinner. I agree. Mom's a little bit thinner. Joanne says, or Joan, is it Joan? I'm sorry, Joan. That burglary charge is confusing. It ought to be kidnapping. Do they have kidnapping? Hold on. They have kidnapping. Yeah, they have second-degree kidnapping on both of them. So Joan, they do have kidnapping there. Hey, Chris Wallace, jury instructions are so boring to me in any trial. Yeah, it's for like the if you're a real law nerd, yeah. It's sometimes can be interesting, but it is sometimes it's tedious, but it's also really gives you the back end, the backside of the law. I like the way the judges and the judge and the lawyers kind of go back and forth trying to hammer it out, though. Hey, Ruth, good to see you. Lynn says, I missed jury instructions. What's up with the burglary charge? That's because she had, Mrs. Ali had a restraining order, a protection order. She should not have been on any property in Thurston County. Is it Thurston? Yeah, Thurston County. And she trespassed. She went into the school. So she broke that rule and she committed a crime. So that's why that's burglary. It's not that you have to take something. It's that you just have to, MLC, there you go. Burglary have to do with entering the school. Yeah, and being on grounds, and being on the grounds. Hey, Alice, good morning to you. Tom saying hello as well. Shirley Stanley, good morning to you. Even Polly saying hello to everybody. So Kimmy, the burglary charge is that she came onto a property that she was not supposed to be on. They had a protection order, restraining order, if you will, because she against Isaiah and then against the school or for the school. So she should not have been on that property at all. And she not only came onto the property, but she actually went into the high school as well. So should be trespassing. That's how they define burglary, is that it's two things. It's willfully being on a property and then willfully committing a crime. It's 2 parts. Hey, Sylvia, good morning to you. Mary, thank you for explaining the burglary charge. No problem. Miss Kitty, wait, I got to pull up Miss Kitty. Miss Kitty, good morning from California. Lynn says, how is Mama's Kitty since surgery? She's good. She's doing fine. Yeah, she's doing fine. She's actually over here. Here, let me show you. I'll show you a quick, hold on. Show you a quick shot of her. She's right there with one of her little kittens. Hi, Polly. What's up? Hi. So that's little mom over there with Sid, and then there's another little dude back here. There's another little dude, and we got, of course, Super Ball. But yeah. Good morning, Mary. Just subscribed. Fantastic. Thank you for joining us. Appreciate that. Appreciate you. And I'm just showing you our new kitties. Hey, Charmaine. Good to see you. Fanny Amy. Fanny Amy. Hazel. Crunchy Frog. Good to see you. Jenny G. Awesome. Love it. Love all the new folks coming in. Miss Holmes. Thank you for your $5. Let's see. Fatima will still be in danger even if dad goes to jail because uncles have the authority to do it and brothers when they teenagers. Yep. Mom could try too. Yeah. No, I know. Thank you, Miss Holmes. Appreciate your support. Thank you so much for that. Yeah. No, her life. It's this drama is not over. Let's just put it that way. Her drama is not over. Hey, Rich Auntie. Good to see you. Anita. If I were there, I'd be on the floor cuddled up with those adorable little fur balls. I know, it's tough. It's tough. Gimme, yes, love the kitties. Princess Mish, hello to you. Marie, good to see you. Red Snap, they are adorable. I know they are. They are. But she was all this time in jail. That should count as credit. Probably will. Probably will. Hey, Barbara, thank you for joining us. Appreciate you being with us today. Nan R, good morning. Oh, Shirley, are you still hurting? I'm sorry. Yeah, that stinks. Hey, Edward, heal up. Shirley, we're sending you all kinds of healing vibes. Real happy. Yep, there's all the little fur babies so far. Emma, good to see you. Shafour, beautiful cat and kittens. Thank you. They did not clip Polly's ears. Nope, we told them no tipping, no tipping. Do not tip their ears. Do not tip her ears. Jeff saying hello, everyone. Should be an interesting day in court. Absolutely. Rosa, possibly the judge thought that it would. We have to go through closing arguments, and then we have to go through jury instructions, 49 lines of jury instructions, which will probably take maybe at least, I don't know, hour and a half, 2 hours. I'm only guessing. Yeah, I'm thinking it's going to be, they won't get it until later in the day. Hey, Joe Schmo, hello, how are you? Thank you for joining us. Thinking out loud, hit the like button, absolutely. Pinky saying good to be here. Let's see. Guys, if you are not familiar with Joe Schmo, he's a fantastic friend of the channel and we of his, so please go and check out Joe Schmo when you have a moment. He was at Lori's sentencing. He was at Lori's trial with Brandon Boudreaux and Charles Daybell. And Charles Vallow. We would do daily recaps with Joe. So he was courtroom insider there. He's got a great channel, Joe Schmo 88. Definitely go check him out. Cloudy Stargazer, good morning to you. Good to see you. Let's see. Can't hear me? Are you guys having problems with my audio down? All right, I think I'm good. I've got kittens crawling around today. Hey, Janet, love from Michigan. Love your work. Thank you, Janet. Appreciate that. Little Lulu, good morning from Western Kentucky. No audio issues? Okay. All right, thanks, guys. Yeah, it must have been just that. Hey, Jen L. Rodriguez, happy Monday to you. Audio's fine. Good. Sounds good to you guys. Oh, good. Kathy, you watched Joe's replay? Awesome. Virginia, yep, check it out. Yep, Joe did a stream on Saturday, talking about his experience there at her sentencing. Gina, good day from Maine. Good to see you. Queen Olive Ruth Ann, yes, congratulations to our newest mods. Yes, we brought on 2 new mods, Aussie Gardner and Joanne Jedi Platypus. So please be kind to them and thank them for being a part of us and joining our team. Rosa, it's very hot in Phoenix. Cloudy Stargazer, they did not testify. They asked them and they did not testify. Sky Girl, hello everybody from Bonnie, Scotland. Good, good. Susie Q, those jury instructions were a tad confusing. Yeah, I hope the jury gets it right. They were so confusing that the judge and the attorneys both said that it was confusing. So when you have a judge and the lawyer saying it's confusing, then you know it's confusing. Hold on, I hear kitties making noise. All right, I gotta make sure they're not chewing on cords. Let me just slow down chat just a little bit. Hold on. I just want to slow this down just a hair. We'll go 5 seconds. I just need to slow this down for my own benefit so I can read the chat. Callie Graham, good morning from Northern California. Good to see you. Thank you for joining us. Hey, Kerviel, how are you? Thank you for joining us. Well, yeah, Anubis, we haven't seen in a couple of days, so we'll just leave it at that. I can't get into details, but we'll just leave it at that. Let's see. When does Slim return? Northwest is asking. Not sure yet. To be determined. Joe says, yeah, Lori, I'm assuming you're talking about Lori, full on, believes her BS. She has to. She has nothing else left. Chad won't even message her. Wow. Princess Mish, thanks, mods. I know what it's like. Thank you, Princess Mish. We appreciate that. And for those that know how difficult it is to keep a chat, kind and courteous and welcoming, please do whatever you need to do to help us out. We appreciate that. Oh my goodness. What? What's with me? Good girl. Hey, Harley Chick. Hello from Ohio. Those are my old stomping grounds, Cleveburg. Will we have a verdict today? Probably not. It will go to the jury. The judge was fairly confident that it will go to the jury. But will we have well, you never know. You just never know. Andrea, whoever gifted me, you're amazing. Thank you so much. Oh, awesome. Fantastic. Let's see. Unbothered, Fatima is being protected in Canada. Oh, I didn't know that. That's cool. Woker than you. What's the maximum sentence for the burglary charge? That I don't know. We'll have to listen to instructions today. Carol says, I thought Lori and Chad were not able to message each other. How would that happen? Yeah, I'm not sure. Verdict tomorrow's your guess, Northwest? Yeah. Hey, Michelle, good to see you. Just a Texan, have they already given jury instructions? No, what they did was on Thursday, which we streamed on Saturday, they just hammered out the instructions. This happens every trial. Judge and lawyers get together and they go over and they just hammered them out. And so they're going to read them actually today. Today they're going to read them. Bacon, when does the court start today? Any minute. They usually are on time. So any minute. Right now we're just waiting for a live feed to kick in. So thank you for joining us while we wait. Chad can't message her directly, Northwest says. Cody Stargazer says, okay, thank you. Sounds like I actually didn't miss anything at all. You really didn't. It was just they were hammering out instructions and it was a little dry. But hey, Pug's Mama, good to see you. Thank you. Tom, I don't expect a fast verdict on this one. Interesting. Melanie, hello from Wisconsin. Thank you for joining us. Appreciate it. Penny, thank you so much for the $10 gift. Thank you so much for your coverage. Are these parents still in jail? What was their bond? Yes, they are in jail. You can check our description. They've been in jail the whole time. Dad was, I think, 1.5 million. I'm not 100% sure about mom. Yeah, I'm not 100% sure about mom. Okay, so the feed from Court TV, which is the feed that everybody's using. Oh, Lord, tell me they're not going to do what they did to us that one time. We may not have a clean feed, you guys. Oh, boy, oh, boy, oh, boy. We may not have a clean feed. Okay. Hold on a sec. I got to tell our mods this. So we may not have a clean feed. They're going to do what they did to us. Possibly, they're going to do what they did to us, which is going to be from their television program, and they're going to stream that. So they're going to have talking heads interrupt us. I just want to prepare you guys. This is what they're showing right now. This is just to prepare you guys. That's what they're showing right now is talking heads. It's not just a straight up feed. So we may have to deal with this again. Hey Donna, hello from Indiana. Good to see you. Thank you. Ms. Holmes, you were born and raised in good old Cleveland. What parts? East of Cleveland. East of Cleveland. Hola, good to see you. Thank you. Let's see, maybe you could watch and tell us what is happening. Well, this is what we're seeing right now. We may not get a clean feed. They did this to us. I forget which day it was, where they had the talking heads come in like every 5 minutes. They'd show like 5 minutes of court if we were lucky, and then they'd have the talking heads come in. So, yep, I know this video just breaks my heart. Oh, I see. Yeah, I thought you meant this. Yeah, no, I know. I agree. Yep, red snap. We may not get a clean feed. So, Joanne, yeah, or Joan. I'm sorry, I keep saying Joanne. Joan. Yep, this trial has been a challenge, that's for sure. And they're the only ones. They're the courtroom feed. We go by. We have nothing. We have no other choice but to go from them because they are the pool feed. And when you're the pool feed, you are there and you broadcast it out to everybody, and you are subject to their whim. Now, what Scott at RA wants to do, and what we did for Sarah Boone, is we went in, we tapped into the court feed, and then we sent it out to our people, so we didn't have to deal with any of this. So, yeah, I have a feeling it's going to be. I have a bad feeling already, you guys. I'm sorry to say, I don't think we're going to have a clean feed. So, it's a shame. It's a shame. Yep, they are the only ones that are covering this. So if somebody else has the feed, it's coming from Court TV. Don't let them fool you. It's coming from Court TV. But if you guys can find another, let me see. Even KOMO News, they're getting it from, let's see. Yep. So KOMO, they're showing it's Court TV. So everybody is subjected to Court TV and the whims of Court TV. So that's what we have to deal with. So it's gonna be terrible. It's gonna be 5 minutes of testimony if we're lucky, and then 5 minutes of commercials. So that's what we have. That's what we get. Virginia, thank you. Appreciate that, and that makes me feel better. Let's see, William. I have hope they will not interrupt closings once they start. Well, what's the saying? Your lips to God's ears. Unfortunately. Yeah. All right. You know what we're going to do? That's a good idea. Well, let's wait until they start. All right. Here's what we can do, you guys. We can pause it and we can let it build up, and then we can zoom through the commercials. And then what I can do is I can play past. I can play. Let me just see what they do. If we'll give them the chance, right? Let's give them a chance. Hey, Silas, good to see you. Let's give him a chance. Yeah, Court TV Northwest. Yep, you got to pay the bills. I get it. I get it. Hey, Ellen, good to see you. How would I say your name? Penny? Good to see you. Thank you for joining us. Let me see. I think so, Selena. It seems like they are. Have they even started yet? No. So, hey, Song Bits Laura, good to see you. So, I'm going to give them a chance. All right, we're going to give them a chance. We'll see what they do. If they're going to do what they did last time, which is, commercial every 5 minutes. Oh, here we go. We got. Hold on. We got it. Whoop, whoop, whoop.
Slide 91. 98 through 102. One 24 to 127. 138 to 140. And obviously they're not numbered as the state is going through and saying them, so that would require immediate to count, but I did want to try and give that at least as a heads up. Names certainly are used throughout. First names generally only unless it is the alleged victim's name in this case. But in terms of photos specifically that depict them, I wanted to at least give that heads up.
All right, thank you. And Ms. Stone, when we discussed this issue last week, you had estimated that potentially 2 hours for your closing. Do you believe that you can finish that many slides in 2 hours?
I think it is going to be very close. Certainly there's a number of, I would say photographs, video that take up a good portion of that, as I have identified. And there is overlap between several of the charges and evidence, so some of those go significantly faster. My hope is to be in 2 hours. I'm also trying to be mindful of not speaking too quickly. Sorry, I put a cough drop in this morning. I know that we have a new interpreter as well. The other interpreters that we've had throughout the trial have indicated that the pace has been fine. But if for some reason that changes, I would just hope that somebody would let me know so I can slow down. But my goal is to be done right at 2 hours. That's the state's intent.
All right. I estimate that it will probably take me about 40 minutes to read the 49 instructions to the jury. So we might be close to 10 o'clock by the time that I conclude. Once I conclude, I will give the jury a stand-up, move around little break. I don't want to interrupt anyone's closing, and I'll address this also with Mr. Kading and Mr. Leary. But I'm hopeful that you will have some sort of natural breaking place so we can take a 10-minute recess during your closing.
Yes, Your Honor. I think that I think there is a natural breaking or pause place so that way folks can get up, go use the restroom, whatever needs to be done.
All right. Thank you. Mr. Kading, do you have any preliminary issues this morning?
No, I was just going to ask about scheduling. Sounds like it's probably going to be just after lunch before defense will start. Is that the plan then? Or?
That's my guess, just based upon the timing with the estimate for the length of the state's closing and taking into account the time it'll take me to read the instructions. I do, and presuming that's around noon, we'll recess for about 30 minutes. The jury will have lunch. And then we will bring them back in for to start with your closing. Also yesterday, on Thursday, you indicated you believed 60 to 90 minutes for your closing. Is that still accurate?
I believe it is.
All right.
I think 60 is actually closer.
All right. So If it's 60, then I think that you just give your entire closing. If it's going to, as you're watching your time getting closer to 90, we may want to just take a stand-up break also, just to give them a little bit of a break. And then Mr. Leary, I would anticipate taking a 10-minute recess after Mr. Kading's closing, so that, and then you would provide your closing, and depending on where we're at timing after your closing, whether or not I just do a stand-up before rebuttal or whether or not we take another 10-minute recess will just depend on where we're at. And you indicated that you believed probably around 60 minutes. Do you still believe that that is likely accurate?
Maybe a little bit over, but not much over.
All right. And same for you, if at some point you think it would be helpful to have a stand-up and take, a couple minutes, and or you think based upon the way everything else is going that a 10-minute recess, please feel free to indicate to me that you think it's a good time for a recess, and I would do that.
I appreciate it.
All right, bring the jury in, please. Please be seated. Good morning, members of the jury, and welcome back. As I told you when we were last in court, what is left is for me to advise you as to the law that applies to this case, and that law is contained in the jury instructions. You have each been provided your own copy of the jury instructions. The only difference between what you have in front of you and what I have in front of me, the originals, which I have, are signed by me and dated with today's date, and the original instructions and the original verdict forms are printed on white paper. Everything that you have is on blue paper. After I read you the instructions, and I'm required to read them to you, then we will begin closing arguments. We do anticipate that closing arguments will take all day today. And as I told you previously, we have ordered or are ordering lunch, and we anticipate probably about a 30-minute lunch break. And we will still have a recess in the morning and a recess in the afternoon, but those might only be about 10 minutes each. All right. These are the court's instructions to the jury. Instruction number 1. It is your duty to decide the facts in this case based upon the evidence presented to you during this trial. It is also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proven, and in this way decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberations consists of the testimony that you have heard from witnesses and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that a witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in my instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by the lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on the lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express, by words or conduct, my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appeared to you that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely. You have nothing whatsoever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions. During your deliberations, you must consider the constructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. Instruction number 2. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors. Nor should you change your mind just for the purpose of reaching a verdict. Instruction number 3. A separate crime is charged in each count. You must separately decide each count charged against each defendant. Your verdict on one count as to one defendant should not control your verdict on any other count or as to any other defendant. Instruction number 4. Each defendant has entered a plea of not guilty. That plea puts in issue every element of each crime charged. The state is the plaintiff and has the burden of proving each element of each crime beyond a reasonable doubt. The defendants have no burden of proving that a reasonable doubt exists as to any of these elements. The defendants are presumed innocent. This presumption continues throughout the entire trial unless during your deliberations you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. Instruction number 5. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. Instruction number 6. A witness who has special training, education, or experience may be allowed to express an opinion in addition to giving testimony as to facts. You are not, however, required to accept his or her opinion. To determine the credibility and weight to be given to this type of evidence, you may consider, among other things, the education, training, experience, knowledge, and ability of the witness. You may also consider the reasons given for the opinion and the sources of his or her information, as well as considering the factors already given to you for evaluating the testimony of any other witness. Instruction number 7. A defendant is not required to testify. You may not use the fact that neither defendant has testified to infer guilt or to prejudice them in any way. Instruction number 8. You may consider a statement made out of court by one defendant as evidence against that defendant, but not as evidence against another defendant. Instruction number 9. A person commits the crime of murder in the second degree when with intent to cause the death of another person, but without premeditation, he or she causes the death of such person. Instruction number 10. A person commits the crime of attempted murder in the second degree when, with intent to commit that crime, he or she does any act that is a substantial step toward the commission of the crime. Instruction number 11. A substantial step is conduct that strongly indicates a criminal purpose and that is more than mere preparation. Instruction number 12. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Instruction number 13. A person is guilty of a crime if it is committed by the conduct of another person for which he or she is legally accountable. A person is legally accountable for the conduct of another person when he or she is an accomplice of such other person in the commission of the crime. A person is an accomplice in the commission of a crime if, with knowledge that it will promote or facilitate the commission of the crime, he or she either 1. Solicits, commands, encourages, or requests another person to commit the crime, or 2. Aids or agrees to aid another person in planning or committing the crime. The word aid means all assistance, whether given by words, acts, encouragement, support, or presence. A person who is present at the scene and ready to assist by his or her presence is aiding in the commission of the crime. However, more than mere presence and knowledge of the criminal activity of another must be shown to establish that a person present is an accomplice. A person who is an accomplice in the commission of a crime is guilty of that crime, whether present at the scene or not. Instruction number 14. The defendants are charged with attempted murder in the second degree. If the defendants were charged with the completed offense of murder in the second degree, the following elements would need to be proven beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant acted with intent to cause the death of Fatima Ali. 2. That Fatima Ali died as a result of the defendant's acts. And 3. That any of these acts occurred in the state of Washington. Instruction number 15. To convict the defendant Ihsan Ali of attempted murder in the second degree as set forth in count 1, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant did an act that was a substantial step toward the commission of murder in the second degree. 2. That the act was done with the intent to commit murder in the second degree. And 3. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 16. To convict the defendant Zahraa Ali of the crime of attempted murder in the second degree as set forth in count 1, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant, as a principal or as an accomplice, did an act that was a substantial step toward the commission of murder in the second degree. 2. That the act was done with intent to commit murder in the second degree. And 3. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 17. A person commits the crime of assault in the first degree when, with intent to inflict great bodily harm, he or she assaults another by any force or means likely to produce great bodily harm or death. Instruction number 18. An assault is an intentional touching or striking of another person that is harmful or offensive. A touching or striking is offensive if the touching or striking would offend an ordinary person who is not unduly sensitive. Instruction number 19. Great bodily harm means bodily injury that creates a probability of death or that causes significant serious permanent disfigurement or that causes a significant permanent loss or impairment of the function of any bodily part or organ. Instruction number 20. To convict the defendant Ihsan Ali crime of assault in the first degree as charged in count 2, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant assaulted Fatima Ali. 2. That the assault was committed by a force or means likely to produce great bodily harm or death. 3. That the defendant acted with intent to inflict great bodily harm. And 4. That this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 21. It is a defense to the charge of assault that the force used was lawful as defined in this instruction. The physical discipline of a child is lawful when it is reasonable and moderate and is inflicted by a parent for purposes of restraining or correcting the child. You must determine whether the force used, when viewed objectively, was reasonable and moderate. You may, but are not required to, infer that it is unreasonable to do the following acts to correct or restrain a child: throwing, kicking, burning, or cutting a child, striking a child with a closed fist, interfering with a child's breathing, doing any act that is likely to cause, and that does cause, bodily harm greater than transient pain or minor temporary marks. You shall consider the age, size, and condition of the child and the location of the injury when determining whether the bodily harm is reasonable or moderate. This inference is not binding on you, and it is for you to determine what weight, if any, such inference is to be given. The state bears the burden of proving beyond a reasonable doubt that the force used by the defendant was not lawful. If you find that the state has not proved the absence of this defense beyond a reasonable doubt, it will be your duty to return a verdict of not guilty as to this charge. Instruction number 22. The defendant is charged in count 2 with assault in the first degree. If, after full and careful deliberation on this charge, you are not satisfied beyond a reasonable doubt that the defendant is guilty, then you will consider whether the defendant is guilty of the lesser crime of assault in the second degree. If, after full and careful deliberation of the lesser charge of assault in the second degree, you are not satisfied beyond a reasonable doubt that the defendant is guilty, then you will consider whether the defendant is guilty of the lesser crime of assault in the fourth degree. When a crime has been proved against a person and there exists a reasonable doubt as to which of 2 or more degrees crime that person is guilty, he shall be convicted only of the lower degree. Instruction number 23. A person commits the crime of assault in the second degree when he or she intentionally assaults another and thereby recklessly inflicts substantial bodily harm or assaults another by strangulation. Instruction number 24. Strangulation means to compress a person's neck, thereby obstructing the person's blood flow or ability to breathe, or doing so with the intent to obstruct the person's blood flow or ability to breathe. Instruction number 25. A person is reckless or acts recklessly when he or she knows of and disregards a substantial risk that a wrongful act may occur, and this disregard is a gross deviation from conduct that a reasonable person would exercise in the same situation. When recklessness as to a particular fact is required to establish an element of a crime, the element is also established if a person acts intentionally or knowingly as to that fact. Instruction number 26. Substantial bodily harm means bodily injury that involves a temporary but substantial disfigurement or that causes a temporary but substantial loss or impairment of the function of any bodily part or organ, or that causes a fracture of any bodily part. Instruction number 27. to convict the defendant Ihsan Ali of the crime of assault in the second degree. Each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant A. intentionally assaulted Fatima Ali and thereby recklessly inflicted substantial bodily harm, or B. intentionally assaulted Fatima Ali by strangulation, and 2. that this act occurred in the state of Washington. If you find from the evidence that element 2 and either alternative element 1A or 1B have been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. To return a verdict of guilty, the jury need not be unanimous as to which of alternatives 1A or 1B has been proved beyond a reasonable doubt, as long as each juror finds that either 1A or 1B has been proved beyond a reasonable doubt. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to either elements 1 or 2, then it will be your duty to return a verdict of not guilty. Instruction number 28. A person commits the crime of assault in the fourth degree when he commits an assault. Instruction number 29. To convict the defendant Ihsan Ali of the lesser included crime of assault in the fourth degree, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant intentionally assaulted Fatima Ali, and 2. that this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 30. To convict the defendant Zahraa crime of assault in the second degree as charged in count 2, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant intentionally assaulted Fatima Ali by strangulation, and 2. that this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 31. A person commits the crime of unlawful imprisonment when he or she knowingly restrains the movements of another person in a manner that substantially interferes with the other person's liberty, if the restraint is without legal authority and without the other person's consent, and the person knows that the restraint is without legal authority and without the other person's consent. Instruction number 32. A person knows or acts knowingly or with knowledge with respect to a fact, circumstance, or result when he or she is aware of that fact, circumstance, or result. It is not necessary that the person know that the fact, circumstance, or result is defined by law as being unlawful or an element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. When acting knowingly as to a particular fact is required to establish an element of a crime, the element is also established if a person acts intentionally as to that fact. Instruction number 33. Restraint is without consent if it is accomplished by physical force, intimidation, or deception. Instruction number 34. To convict the defendant Ihsan the crime of unlawful imprisonment as charged in count 3, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. that on or about October 18, 2024, the defendant knowingly restrained the movements of Fatima Ali in a manner that substantially interfered with her liberty. 2, that such restraint was without Fatima Ali's consent. 3, that the defendant knew that such restraint was without Fatima Ali's consent. 4, that such restraint was without legal authority. 5, that the defendant knew that such restraint was without legal authority. And 6, that any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 35. To convict the defendant, Zahraa Ali, crime of unlawful imprisonment as charged in count 3, each of the following 6 elements of the crime must be proved beyond a reasonable doubt. 1, that on or about October 18, 2024, the defendant, as a principal or as an accomplice, knowingly restrained the movement of Fatima Ali in a manner that substantially interfered with her liberty. 2, that such restraint was without Fatima Ali's consent. 3, that the defendant knew that such restraint was without Fatima Ali's consent. 4, that such restraint was without legal authority. 5, that the defendant knew that such restraint was without legal authority. And 6, that any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 36. Family or household member means a persons who have a biological or legal parent-child relationship, including step-parents and stepchildren, and grandparents and grandchildren. Instruction number 37. It is a defense to a charge of assault in the 4th degree as charged in count 4 as to Ihsan Ali that the force used was lawful as defined in this instruction. The use of force upon or toward the person of another is lawful when used by a person who reasonably believes that he is about to be injured in preventing or attempting to prevent an offense against the person, and when the force is not more than is necessary. The person using the force may employ such force and means as a reasonably prudent person would use under the same or similar conditions as they appeared to the person, taking into consideration all of the facts and circumstances known to the person at the time of and prior to the incident. The state has the burden of proving beyond a reasonable doubt that the force used by the defendant was not lawful. If you find that the state has not proved the absence of this defense beyond a reasonable doubt, then it will be your duty to return a verdict of not guilty as to this charge. Instruction number 38. Necessary means that under the circumstances as they reasonably appeared to the actor at the time, 1, no reasonably effective alternative to the use of force appeared to exist, and 2, the amount of force used was reasonable to effect the lawful purpose intended. Instruction number 39. It is lawful for a person who is in a place where that person has a right to be and who has reasonable grounds for believing that he is being attacked to stand his ground and defend against such attack by the use of lawful force. The law does not impose a duty to retreat. Notwithstanding the requirement that lawful force may be not more than is necessary, the law does not impose a duty to retreat. Retreat should not be considered by you as a reasonably effective alternative. Instruction number 40. No person may, by an intentional act reasonably likely to provoke a belligerent response, create a necessity for acting in self-defense, and thereupon use or attempt to use force upon or toward another person. Therefore, if you find beyond a reasonable doubt that the defendant was the aggressor and that the defendant's acts and conduct provoked or commenced the fight, then self-defense is not available as a defense. Instruction number 41. To convict the defendant Ihsan Ali of the crime of assault in the 4th degree as charged in count 4, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant assaulted Isaiah Williams. That this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 42. A person commits the crime of burglary in the 2nd degree when he or she enters or remains unlawfully in a building with intent to commit a crime against a person or property therein. Instruction number 43. A person enters or remains unlawfully in or upon premises when she is not then licensed, invited, or otherwise privileged to so enter or remain. A license or privilege to enter or remain in a building that is only partly open to the public is not a license or privilege to enter or remain in that part of the building that is not open to the public. Instruction number 44. A person who enters or remains unlawfully in a building may be inferred to have acted with intent to commit a crime against a person or property therein. This inference is not binding upon you, and it is for you to determine what weight, if any, such inference is to be given. Instruction number 45. The term premises includes any building, dwelling, or any real property. Instruction number 46. To convict the defendant Zahraa Ali of the crime of burglary in the 2nd degree as charged in count 4, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant entered or remained unlawfully in a building. 2. That the entering or remaining was with intent to commit a crime against a person or property therein. And 3. That this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 47. A person commits the crime of violation of a court order when she knows of the existence of a protection order and knowingly violates restraint provisions of the order prohibiting contact with the protected party, or a provision of the order excluding the person from a school, or a provision of the order prohibiting the person from knowingly coming within or remaining within a specified distance of a location. Instruction number 48. To convict the defendant Zahraa Ali of the crime of violation of a court order as charged in count 5, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, there existed a protection order applicable to the defendant. 2. That the defendant knew of the existence of the order. 3. That on or about said date, the defendant knowingly violated a restraint provision of the order prohibiting contact with a protected party, or provision of the order excluding the defendant from a school, or a provision of the order prohibiting the defendant from knowingly coming within or remaining within a specified distance of a location. And 4, that the defendant's act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 49. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 12 jurors are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias or prejudice. If during your deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes that you have taken during the trial if you wish. You have been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. If after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly. For this purpose, use the form provided in the jury room. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to the bailiff. I will confer with the lawyers to determine what response, if any, can be given. You will be given the exhibits admitted in evidence, these instructions, and verdicts forms A, B, BB, BBB, C, and D for the defendant Ihsan Ali, and verdict forms A, B, C, D, and E for defendant Zahraa Ali. Some exhibits and visual aids may have been used in court, but will not go with you to the jury room. The exhibits that have been admitted into evidence will be available to you in the jury room. When completing the verdict form for count 2 for the defendant Ihsan Ali, you will first consider the crime of assault in the first degree as charged. If you unanimously agree on a verdict, you must fill in the blank provided in verdict form B the words "not guilty" or the word "guilty" according to the decision you reach. If you cannot agree on a verdict, do not fill in the blank provided in verdict form B. If you find the defendant Ihsan Ali guilty on verdict form B, do not use verdict form BB. If you find the defendant Ihsan Ali not guilty of the crime of assault in the first degree, or if after full and careful consideration of the evidence you cannot agree on that crime, you will consider the lesser crime of assault in the second degree. If you unanimously agree on a verdict, you must fill in the blank provided in verdict form BB the words "not guilty" or the word "guilty" according to the decision you reach. If you cannot agree on a verdict, do not fill in the blank provided in verdict form BB. If you find the defendant Ihsan Ali guilty on verdict form B or BB, do not use verdict form BBB. If you find the defendant Ihsan Ali not guilty of the lesser crime of assault in the second degree, or if after full and careful consideration of the evidence you cannot agree on that crime, you will consider the lesser crime of assault in the fourth degree. If you unanimously agree on a verdict, you must fill in the blank provided in verdict form BBB the words "not guilty" or the words "guilty" according to the decision you reach. If you cannot agree on a verdict, do not fill in the blank provided in verdict form BBB. You will also be given special verdict forms A1, B1, BB1, BBB1, and C1 for defendant Ihsan Ali for the crimes charged in counts 1, 2, and 3. If you find the defendant not guilty of these crimes, do not use the special verdict forms. If you find a defendant guilty of these crimes, you will then use the special verdict forms and fill in the blanks with the answer yes or no according to the decision you reach. In order to answer the special verdict form yes, you must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer. If you unanimously agree that the answer to the question is no, then you must fill in the blank with the answer no. If after full and fair consideration of the evidence you are not in agreement as to the answer, then do not fill in the blank for that question. You will also be given special verdict forms A1, B1, and C1 for defendant Zahraa Ali for the crimes charged in counts 1, 2, and 3. If you find the defendant not guilty of these crimes, do not use the special verdict forms. If you find a defendant guilty of these crimes, you will then use the special verdict forms and fill in the blank with the answer yes or no according to the decision you reach. In order to answer the special verdict form yes, you must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer. If you unanimously agree that the answer to the question is no, then you must fill in the blank with the answer no. If after full and fair consideration of the evidence you are not in agreement as to the answer, then do not fill in the blank for that question. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the proper form of verdict or verdicts to express your decision. The presiding juror must sign the verdict forms and notify the bailiff. The bailiff will bring you into court to declare your verdict. The following pages after instruction 49 are the verdict forms that I have referenced. Members of the jury, we're going to just do a quick little stand up and then we'll start the closing arguments. All right, we'll have everyone have a seat. Members of the jury, if you would please give your full attention to Ms. Stone as she makes closing argument on behalf of the plaintiff, the state of Washington.
Thank you. Counsel. Ladies and gentlemen, so a couple of weeks ago when we came in and we started this, we indicated you would be here for several weeks, and there was a lot of information that you were going to get. We have reached that point where you've now been informed on the law by the court. You have a fairly lengthy packet of instructions, and you've heard a lot of evidence over the course of the last several weeks. I will tell you that there is no fast way to get through all of that evidence and compare it to the instructions. The court, I think, has informed you, and you'll hear it again. The state has the burden. That is properly the state's burden, and the state accepts that burden. But what that means is I am responsible for proving to you every element of every crime that has been charged. So we have to take some time to do that. And then at the end of this, because it's the state's burden, I get to talk to you again. I promise you the second time will be much shorter. But if at any point during the course of this, someone needs a break, you can't hear something, you just need to stand up, please catch our attention. We will plan to take a break, but we want to make sure that if someone needs that earlier, you let us know, okay? So I have slides. Everybody processes information differently. Lots of you take notes. You can see that the attorneys take a lot of notes too. Some folks are much more auditory processors, and some folks are very visual processors. So I've tried to give you a number of different ways, as the court has during the course of this as well, of processing that information. If slides do not work for you, then please ignore them and don't pay attention to them. It helps me stay on track. It helps me present it in a more organized fashion, but that may not work for everyone else, okay? So don't feel like you have to pay attention just because they are there. Make sure that, there we go. So I always start with this first slide, lawyer statements. Lawyers talk a lot, right? It's what we do. You are going to hear obviously from the group of us, first myself, then Mr. Kading, then Mr. Leary, and then me again. What we tell you is not evidence. The evidence is the testimony and the exhibits that came from the individuals that were sitting in that seat over there. The attorneys will tell you things. We will argue to you the evidence we believe that you have heard over the course of the last several weeks. Attorneys are human too, and whether it is myself or Mr. Kading or Mr. Leary, what we tell you is not evidence. So if we misspeak, if we say something that we believe a witness has said or we recall a witness having said, and that does not jive with your memory of those events or your notes or your recollection, your memory, your notes is what the evidence is. We are not the triers of fact. We are just the attorneys, okay? So please rely on the instructions you've been given by the court and your recollection in those notes. So evaluation of the evidence. We provide this instruction also as well. Oftentimes you will hear folks during the course of whether it's a TV show or an argument or something else. Well, it's just circumstantial evidence. It doesn't mean anything. That's an inaccurate statement. When you come in, at least in the state of Washington, when you come in here, you do not come in here in a vacuum of life experiences. We want a fair and impartial jury, both for the state and for the Alis. We want to ensure that that is what you are there to do, but we do not assume that you have no life experiences and you cannot process information about what is reasonable behavior, what is unreasonable behavior, and reasonable inferences to take from those. So in Washington, we give you that distinction between direct and circumstantial evidence. Direct evidence is that thing that you have directly perceived. Circumstantial evidence is the thing that you know and you can make a reasonable inference from. So let me give you an example of that. And we use a cake example very often, right? If you go in and you make a cake, everyone who's ever made a cake knows you cannot frost a hot cake, right? My bakers know that. That frosting's going to slide right off the side and be a gooey puddle. It will look nothing like what it's supposed to do. So if you make your cake, you have to let it sit out and cool. So now let's say that you've made that cake. It is sitting out, it is cooling, and you live alone, you live with your dog, and you have errands to run. So you lock your doors, your windows are all locked, nobody else is there. You come back a couple hours later, and what was once a beautiful cake waiting to be frosted is now in shambles on the floor. There's crumbs everywhere, your dog looks comfortably full, and there's crumbs all over the dog's face. Direct evidence would have been a video watching your dog eat that cake. Circumstantial evidence is exactly what we've just described. You know your dog ate the cake. That is the only reasonable inference that comes from that evidence. You didn't see it, but you know that that's what happened. There's no other reasonable explanation. No one's broke in. You said no one lives there. There's no windows. That's what happened to your cake. That is circumstantial evidence. And that is in large part why we provide you this instruction, but we trust that you are going to use your rational mindset and your common experience to know what facts and inferences to take from the evidence that you see. There may be differences in types of evidence that you receive, but the fact that one is circumstantial and one is direct makes no difference in terms of the weight that you give it, just by definition. So please don't get stuck in that loop in deliberation, like, well, it was only circumstantial, or oh, it was direct, so that's better than this kind. That's not the case. Like I say, that individual piece of evidence may have a different weight, but that weight is not drawn from whether it is a piece of direct evidence or a piece of circumstantial evidence, okay? So evaluation of the witness testimony. Our way through those. In addition to the fact that you are the triers of fact, the sole triers of fact, you are also the sole judges of credibility. The attorneys are not. We cannot comment on the credibility of witnesses. We can point out whether there was a particular manner about a witness testifying, whether there was a personal interest, whether there's a reasonableness of the statements that they may have provided to you in context of everything else that you saw, but you are the sole judges of credibility. So when you are looking at the testimony of witnesses and how to evaluate that, you are given an instruction about some of the things that you can look at to help assist you in that process, okay? Reasonable doubt. Before you came into trial, if you've never sat on a jury before, But before you came in here, I believe that you would probably describe yourself as reasonable people. Most people would describe themselves as reasonable people. Having sat in here now and gone through all of these instructions, I would submit to you that we have ruined you with the law. You are no longer reasonable people. When you go back home and you're talking to friends when this is all over, or talking to your family, when the court has released you from your instructions not to talk about it, you can say, well, I don't know, I had a reasonable doubt. We didn't convict on A, B, and C, or at all because I had a reasonable doubt. Or we convicted them on A, B, and C, or we convicted them on all because we had an abiding belief in the truth of the charge. Nobody talks like that. Lawyers talk like that, right? But now you will talk like that, at least as you're evaluating this and in talking to each other in that back room. So what does reasonable doubt mean? And you have the instruction. I submit to you that reasonable doubt and abiding belief are two sides of the same coin. If you have an abiding belief, then you do not have a reasonable doubt as to the truth of the charge. An abiding belief is abiding, long-lasting. You believe it today, you believe it tomorrow, you believe it next week, next month, next year. That is an abiding belief in the truth of the charge, that the defendant did what the state has charged them with, and that the state has proven that beyond a reasonable doubt. You have an abiding belief. If you have a reasonable doubt, then you cannot have an abiding belief in that truth of that charge. Right? So it is not, there's no numeric value that you can apply to it. It's not a 51% or a 75%. Reasonable doubt is one of the highest standards certainly that we have, and we talked about that during voir dire, but it is not 100% either. So there is no numeric value associated with reasonable doubt. But as it says, if you have an abiding belief in the truth of the charge, then you do not have a reasonable doubt. And it's just another way of, I think, talking about that and evaluating within yourself. It's kind of this, amorphous is not the right word, but we as humans really like objective measurements, and there's no objective measurement associated with reasonable doubt. So you really have to look at this standard as you're talking about it and thinking about it amongst yourselves, whether it has been achieved, okay? Things you will not get. The court told you this just now in the instructions. Ms. Zoe talked to you about it during opening arguments, or excuse me, opening statements, if you recall. You are not going to get certain documents. And that I know is frustrating every time for a jury because people have referenced them. But the reason that you don't get them is exactly what we talked about, because the testimony is the evidence. A police report is not evidence. If that were the case, we wouldn't call anyone into court. You wouldn't hear from witnesses ever. We'd have them write a statement, you'd have police reports, you'd get doctor's reports, and you would never have anyone come in and testify. In the law, we value the testimony of people who are coming to tell you what they saw, what they heard, what they observed, what happened related to these events. And that is why the testimony comes from the person sitting in that stand. That's why you don't get police reports that officers have made along the way. You're not getting medical reports because the doctors came and told you what is contained within those reports and told you what they observed. Prior statements of witnesses, you don't get those either, right? That's why we have cross-examination, why we have direct examination. So please don't ask for them because they are not coming. You have to make your decisions based on the information that you have heard and what you have received as exhibits, and as we go through this process, right, talking to each other. And then last, of course, transcripts of any trial testimony. You're not getting any transcripts of, can we get a transcript of what so-and-so said on such and such day? That's not coming either, okay? So as you are going through and organizing your thoughts, please keep that in mind. There's a lot of overlap. So I'm going to tell you that there is approximately, if I did my math right, 11 different crimes that I have to go through and describe to you. There's a lot of overlap in that evidence. So I've tried to break it down as we go through those crimes where there is a overlap between both parents, and then we'll separate out some of the parents. So let's start first with count number 1, attempted murder in the second degree of that victim, Fatima Ali, for both parents, Ihsan and Zahraa Ali. Attempted murder in the second degree. I think it's instruction 14, I believe, gives you what it looks like if there is a completed murder in the second degree. Please do not get caught up in that is what the state has to prove. That is not the case. Instruction 14 shows you what completed murder in the second degree would look like. Instruction number 15 tells you what attempted murder looks like. If they were to have done this and completed it, this is what the state would have to prove. Instruction 15, I believe, is the one that says, but here are the actual elements that the state must prove, and that is a substantial step. A substantial step needs to occur. So a person commits the crime of attempted murder in the second degree with intent to commit that crime. He or she does any act that is a substantial step toward the commission of that crime. Okay? There is the completed murder in the second degree. A person commits the crime of murder in the second degree when, with intent to cause the death of another person, but without premeditation, he or she causes the death of such person. Then you are given what I'll call a bunch of definitional instructions. This one is as to the mental state. So intent, a person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Here's your definition for substantial step. A substantial step is conduct that strongly indicates a criminal purpose and that is more than mere preparation. It's not simply thought, but it is an act in furtherance of that intent. So these are what we talked about initially. The defendants are charged with attempted murder if, and I don't know that my red, it's a giant red dot, so you can see the if underneath, right? If the defendants were charged with the completed offense, this is what the state would have to prove, right? But because it is attempted, this is what the state actually has to prove. That on or about October 18th, the defendant did an act that was a substantial step toward the commission of murder in the second degree, that the act was done with the intent to commit murder in the second degree, and that any of these acts occurred in the state of Washington. And then when we talk about Zahraa Ali, the only difference between Ihsan and Zahraa is that Zahraa is charged as a principal or as an accomplice. Ihsan is only charged as a principal. Zahraa is charged in both fashions. So principal, you do it yourself without any help, or accomplice, that you were doing it to assist. You're assisting another in reaching their goal. So let's talk first about elements 1 and 3 for both parents. When we talk about elements 1 and 3, there's going to be, as I said, overlap. These are the elements that I anticipate there's not going to be a lot of argument from. I still have to prove them to you. The state still has, beyond a reasonable doubt, responsibility for proving these, but defense counsel, I don't believe is likely to argue that it didn't happen on October 18th and it didn't happen in the state of Washington. So here's the evidence that applies for each of those, right? All testimony agrees that this was Friday, October 18th, 2024. You have the bus and the body cam videos that you saw that confirmed that, and then you have the testimony of the date and time of those school videos that Celeste Waltermeyer talked about. When we pull it and download it, those dates are not shown on that video, but that's specifically the date, time, range that I was looking and pulling from. And that information that you see in context on those school videos themselves from Timberline High School are consistent with what you see in context from all of the other videos. So I submit that that's accurate. She didn't pull a different date or a different time, right? Element 3, that these acts occurred in the state of Washington. This is Timberline High School. That testimony occurred over and over again. 6120 Mullen Road, Southeast, Lacey, Washington. And all of that testimony confirms the same. You're going to see this, a variation of this slide, a number of times because it applies to every single count that we have, okay? So, again, what exhibits do we have that demonstrate that as well? Here is Exhibit 1. You have that bigger aerial photo. You have Timberline High School. You have the parking lot here. Now my red dot is covering towards the bottom center of that page where that bus stop is, and you have Mullen Road that runs diagonal across that page. Exhibit 2, bigger shot of the same thing. Again, at the bottom left corner, you have that bus stop identified. Mullen Road is identified. You can see that parking lot that we've watched several videos of throughout this trial. And you can see the crosswalk running diagonal across the parking lot, but almost directly perpendicular up and down on this page with the white dashes running across it just to the left of center. Right, that's the crosswalk that we observe Fatima and Isaac during the course walking to the bus stop, and then again people describing later towards the Timberline High School, which is outside of this photo but would be at the very top of it, right? That's where those front doors are. So then we talk about let's talk about the rest of element 1, right? Remember, element 1 under attempted murder has a couple of different things within that element itself it has to prove. So the rest of element 1, speaking first to Ihsan Ali did an act that was a substantial step toward the commission of murder in the second degree. So what evidence do you have of that? What facts did you hear during the course of this trial? First, you have that he grabs Fatima by the hoodie and places her in a rear naked choke. Let's be clear, the state is not asserting that Ihsan Ali showed up on that day with the intent to try and kill his daughter. There was no premeditation that the state is asserting, but by the time Ihsan goes into these events, the state's position is that that has changed. His intent has substantively changed. He grabs her by the hoodie and he places her in a rear naked choke, and we've heard that described with specificity. He takes her to the ground. He holds her in that choke for an extended period of time. He ignores those repeated screams and demands of no less than 6 kids. There's probably more there at varying times, but there's approximately 6 that are there pretty consistently throughout that entire process. And 2 separate adults to release her. We see Mr. Denicola come up on the scene in his bright orange vest. We see later Josh Wagner arrive on scene, and they're all saying the same thing. They're all screaming at him to release her, to let her go. Denicola, I think even at one point, I submit when you watch that video, is pointing a finger, and he's telling you, he told you in his testimony, I was telling him to let her go, to release her, to let her go, and he was just doing nothing. He was ignoring me. So it's not just kids that are running around. There's no chaotic panic. These are adults that are watching it happen and very clearly know that this is wrong. They're screaming that she can't breathe and he's killing her. And you hear that on the video. He continues to hold her while she fights and struggles. There's an apparent seizure. She goes limp, and then she is unconscious. The testimony by everyone is that her eyes have rolled back in her head, her face is pale, her lips are blue, and I believe Josh Wagner says she has changed colors. When asked on direct examination, Mr. Wagner, based on what you observed, and you came to it towards the end, based on what you observed, is there any way that could have been confused with hugging or simply restraining that child? And his response is no, it's very obvious she was being choked. That was Josh Wagner's statement. And then you have Exhibit 61, which is Elijah's video, that shows you exactly the same thing. So I submit to you that that substantial step towards murder in the second degree has been taken. So then element 2, that the act was done with the intent to commit murder in the second degree. So what evidence have you heard throughout this trial that shows that? First, he holds her throughout all of that and continues to hold her after. The only time he releases her is when Josh to release her. All of these things are happening. This is not a like, oh gosh, it happened so fast, I had no idea what to do. It is an extended period of time, and he continues to hold her. Denicola, remember, he testifies that his arm is straining around her neck, that Ihsan's arm is clearly, there is a tension there. His hands are locked. Mr. Denicola's statement was, when asked, well, how do you know, what did that look like? And he was like, it was the look on his face. So he is there with them on the ground, and Ihsan's face clearly demonstrates to Mr. Denicola the intent behind what Ihsan Ali is doing to his child. It is so upsetting, in fact, Mr. Denicola testifies towards the end that he calls his supervisor to call it in, and says he is in shock. He's trying to process what he just saw, and he has to pull the bus over on the side of the road, and his supervisor has to come take his route. That is how upsetting. This is not a group of kids that are just overreacting to a situation. That is how upsetting that event was to Mr. Denicola. And he's described, I have security camera on my bus. I've had to look for a bunch of things. Fights, whatever. He had to pull his bus over to process what he saw here because it was so upsetting. So what does that tell you? How is this different from the objective observer that doesn't know any of these individuals from Adam about what he observed from Mr. Ali's intent? That it was an intent to commit murder, not something else. You have Caleb talks to you about we're trying to get him off. In fact, I'm pulling so hard at his arms that he tears Ihsan's coat, and still he doesn't release. Nothing changes, and you see evidence of that coat tear later. It is shredded down his arm. Ihsan doesn't let go. He is holding on to Fatima's neck throughout. He releases only when he is physically forced to do so, despite, and go back and watch the video I submit to you, she has stopped struggling for approximately 15 to 18 seconds prior. She's unconscious, and he continues to strangle her around the neck for another 15 to 18 seconds, and would have continued to do so even longer, but for the intervention of those adults. Then you have Dr. Gilbert's testimony about the effects of strangulation on the body, what happens, and why that happens. She talked to you about the jugular vein inclusion, carotid artery inclusion, and tracheal inclusion. Remember, the lack of, starting first with jugular vein inclusion, the lack of removal of deoxygenated blood. Those are those thin-walled veins on the outside of your neck, right? You need the bad blood to come out of your brain so your brain can function. And we'll come back to the pressure, but it's about 4 pounds of pressure for that jugular vein occlusion, one on each side, thin walls. Then she talked about the lack of oxygenated blood to your brain. That is that carotid artery occlusion. Those are thicker walled arteries, and they are deeper within your neck, right? And that is greater pressure to close. She said about 11 pounds, I believe. And then she talks about what that lack of oxygen to the brain and that buildup of pressure does in the brain, how that leads to brain death, which is death. So then we talk about element number 1 for Zahraa, as a principal or as an accomplice. So remember first, this is generally speaking what it means, that language principal or accomplice means. All assistance by words, acts, support, or presence, and present at the scene and ready to assist. First we have, well, let me back up for one moment. When we talk about principal or accomplice, it's really obvious what principal is, right? You're the person doing it, you don't have any help, you're doing it sort of independently yourself. As an accomplice, if you're assisting someone else. And we distinguish, I'll give you a bank robbery as kind of the classic example. When we distinguish an accomplice in like a bank robbery identification, right? We want to talk about the people that are there to help assist the principal in doing whatever the principal is doing, generally robbing the bank. We want to distinguish that person from the customers that are present, that are there to do business. They know a bank robbery is happening, they're present, and they're aware, but certainly we wouldn't identify the customers as accomplices in that case. We would identify the getaway driver, the lookout, the other person who's providing the banking information or copies of the key. We would describe those people as accomplices. And even the lookout, right? They may not even actively touch anything. They may literally just stand at the door, but they are still identified as an accomplice. So that accomplice liability instruction, and you have it in your instructions, I don't recall the number off the top of my head, but that is what distinguishes somebody who's just present and has knowledge of what's going on from the person who is actively engaged in trying to fulfill the goal or extend the behaviors of the principal, right? All assistance by words, acts, support, or presence, and present at the scene and ready to assist. That is your accomplice liability instruction. So what do you have? You have Exhibit 34 at 2:13:57 on Exhibit 34, and that's that the bus video, the road view of that bus video. Mrs. Ali arrives at that tree. Josh Wagner, white line, he's still in the street on Mullen Road. Ihsan is struggling with Fatima, but Zahraa is already there. She is a couple steps ahead of Josh Wagner. 2 seconds later, same exhibit, you see that Zahraa is at the group. She is bent down with Fatima. Her arms are outstretched. Josh Wagner has just reached the dirt. He's not even at the group yet. So he's not there. He hasn't interrupted the strangling, but Zahraa is there, and Zahraa's not like somewhere else. Zahraa is right there. She is bent down with those individuals. These are separate acts and behaviors from those of the kids watching, because what are the kids doing? The kids are still screaming, "Get off of her, let go of her, you're killing her." And what does Mary Wagner say? Mary Wagner says, Zahraa is not helping the young woman on the ground. She seems to only be trying to stop the teens from hitting the man who is strangling Fatima. She did nothing to assist Fatima from what Mary Wagner saw. That's, I submit to you, what you see on the video. It's fast. Remember that those videos go, they pause, they go in slow motion, and you have access to those to fully and fairly consider that. But she goes in and she immediately is pushing kids, but she's not providing assistance to Fatima. Neither Josh Wagner or Denicola describe any assistance for dislodging Fatima by any other adults. They're the only two that are in there trying to get Ihsan Ali's arms pried off of the neck of his daughter. No one else, in terms of adults, are doing that. Then you have Exhibit 122 plus Mrs. Ali's statements. She clearly expresses over and over again to law enforcement that her concern is for the kids that are hitting and striking her husband, not Fatima. In fact, she doesn't even mention that her husband has been strangling Fatima. But she's there. We know she sees it. Everybody else sees it. But she says not a word about how her child has been strangled into unconsciousness. And we know by the time she arrives, Fatima is unconscious. She is pale, her lips are blue, and she is laying still, because there's only about a handful of time from the time that she gets there to the time Josh Wagner is able to get Fatima released. And what does Josh Wagner say? He immediately knows that a child is being choked. He doesn't say, when I got up, I could see that it was a child being choked. When I got out of the car and started coming across the street, I could immediately see this is a child that is being strangled. Immediately. And again, he doesn't know these individuals from Adam, but Mrs. Ali does. In fact, she's outside of Isaiah, is really the only one who knows exactly who is strangling and who is being strangled. And she doesn't mention a word to law enforcement. Remember what Officer Bell says. When asked, how long until you knew? He was like, at the end. It was basically to the end of my time there on scene before I had any idea that Fatima had been strangled. Because even though I had talked to mom and had interactions with mom, she didn't say anything about it. Not a thing. So we have to go through the accomplice liability and the principal for Zahraa. So element 1, as an accomplice. What evidence do you have? As an accomplice, at 2:13:55 into that exhibit. And remember, that's the date time. In Exhibit 34, it has the date time stamp on the bottom. So 2:13:55, Fatima goes unconscious. So we know she's already in that state by the time mom gets there. Her face is pale, her lips are blue. Ihsan is still actively strangling Fatima at that time. We said she knows what's going on because it's apparent to everyone else, immediately apparent to everyone else. And Zahraa is the only one that knows those individuals. And that she's attempting to intervene on behalf of her husband while he is still actively choking Fatima. Not Fatima. She's not attempting to intervene on behalf of Fatima. That is a substantial step. That is more than mere presence and knowledge at that scene. We know that Fatima is not released by Ihsan until about 2:14, 10 to 13. So that if you look at that video and watch, somewhere between 10 seconds after and 13 seconds after, that is when we know Fatima gets released. So there's a period of about 11 to 14 seconds where mom is assisting Ihsan and not Fatima by trying to prevent assistance to Fatima from those kids. So again, as an accomplice, element 2 for Zahraa, that it was done with the intent to commit murder in the second degree, that she is actively watching her husband strangle her child in that rear naked choke with the arms tightly locked around her child's neck. She is actively able to see what every other person has described as Fatima's appearance throughout that time. She has time to view the situation and make a decision to try and remove impediments and prevent injuries to her husband. So we know she's able to quickly evaluate a situation and take actions based on her evaluations. To be clear, this is not a complicated fact pattern to evaluate when you have arrived on that scene. Everybody says so. Everyone that's present says so. Every other person immediately knows the danger, obvious danger of death to Fatima, but somehow mom doesn't. So what do we take from this? Her loyalty is to her husband and his purpose, not to her child. So then as a principal, what is the substantial step, the evidence you have of a mom as a principal? She's just watched her child being choked and unconscious for approximately 11 to 13, 14 seconds per that bus camera video. Fatima is then released. Josh Wagner gets her released. She is incoherent. Remember what Fatima says. The last thing she sees, remember seeing is Isaiah on her face and bushes, and the next thing she knows, she is in her mom's arms, and her mom has her arm around her neck. She is not there. Mary Wagner talks about that, that girl is not there. I don't have another way to describe that. She just was clearly not aware of what is happening around her. She has come out of that unconsciousness. But mom immediately wraps her arms around Fatima's neck. Her ability to breathe, Fatima says, I can't breathe. I'm trying to tell my mom, but everyone describes nothing is coming out. There's no sound coming out. Denicola says he remembers hearing her being almost raspy, whispery, but she wasn't really making sound. And plainly he said, I wasn't looking at that. I saw what appeared would be a mom and the child, so I assumed they were fine. My focus is on dad because that's where the immediate threat was. And I was trying to pay attention to the immediate threat, but I remember hearing this very whispery, raspy. That is consistent with what Fatima told you that she was trying to do. Trying to tell her mom, I can't breathe, and her mom doesn't let her go. So what happens? Then the kids intervene as well. That's the substantial step. Dr. Gilbert, again, all of that same information about the effects of strangulation on the body and why. And certainly, if you've just been strangled for 45 seconds, being strangled a second time doesn't improve that condition. You don't start over from zero as if the first time it never happened. It is a continuation of that strangulation. So what is the information that the act was done with the intent to commit murder? Same intent as accomplice liability. That hasn't changed. She has actively watched her husband strangle her child. She's actively able to see what everyone else has described. She's had time to view that situation and make decisions to try and remove those impediments to her husband and prevent injuries. And she's had, at this point, when she is separately strangling her daughter, has even more time now, knows the danger, and does it anyway. She does it anyway. That is not an effort to comfort her child. Again, that is not where her loyalty lies in this situation. And she demonstrates that over and over and over again during the course of those videos. So here is that bus video. I'm going to play it in regular speed. You can play it whatever speed you want. This is what you see from the backside, right? They've now run away. And this is the face of Isaiah and Fatima as they are running to the school for help. That is not the face, I submit to you, of children who are just goofing off, who just believe that they are trying to get away from their parents because they're going to get in trouble. Evaluate what that face looks like as Fatima's running away from her parents. Look at Fatima's face when she comes in Exhibit 111, page 3 of that, because it comes in a packet of still shots. Look at Fatima's face when she comes in that office. You heard Tracy Arnold testify that she looked like she was in terror. She was frantic. Submit to you that is consistent with what Exhibit 111 presents. Now you also have a instruction attached to a special verdict form. Everything that is a -1, essentially, in your packet. You have a lot of verdict forms, you guys. Everything that is a -1 is what we'll refer to as a special verdict form, and you have to just answer yes or no. And that is, essentially is, depending on which count it is Ihsan a family or household member, or is Zahraa a family or household member of Fatima? And here's the instruction that describes what a family or household member is. It's exactly what you would think it is, right? If you are a biological or legal parent-child relationship. So in terms of the elements, attempted murder in the second degree, family or household member, on special verdict form A1, Ihsan Ali is Fatima's father. Everybody says so. Fatima says so, right? In fact, part of the defense that has been provided to you is that they are parents, they are her parents, and so therefore they get to behave in a particular way. So I submit to you this is not an argument between the parties. You still have to find it, again, beyond a reasonable doubt. The parties are not arguing about whether Ihsan and Zahraa are Fatima's parents. So the answer, if you convict on any of those charges, the answer on each of them should be yes. So now we're going to jump over to count 3, unlawful imprisonment of Fatima, again, for both parents. Your Honor, it sounds like maybe we need a break.
All right, I'm going to ask the bailiffs to come forward, and we're going to take a recess for 10 minutes. Remember, you are hearing closing arguments and deliberations has not begun. You are not to discuss anything during this break. We'll be in recess for 10 minutes.
All right, welcome in, everybody. Thank you for joining us. We'll get through a little recap here while they take their 10-minute break. So, Judge went through her jury instructions. Judge Schaller, Christine Schaller. She went through her 39 lines of jury instructions, and I'll go through them real quick here. Oh, first of all, so the judge estimated 40 minutes for 49 instructions, and then defense. Let's see. Both defense just after lunch for them to start. So the defense thinks they're going to start just after lunch. Oh, state said it might be 2 hours. They said it might be 2 hours. I don't know how long she's been going for. Miss Stone, let me just see how long she's been going for. She has been going. She's been going for about 45 minutes. All right, so she's saying it might be 2 hours. She's hoping it's faster than 2 hours. But remember, there's 12. No, there's 11. There's 11 charges. She has to get through 11 charges, right? So Judge Schaller went through the jury instructions. The ones that I'm not going to bore you with them again, but the meat of it was she talks about the different charges, and she basically they're all of these. So there are the charges: attempted second-degree M, attempted first-degree kidnapping, attempted second-degree kidnapping, second-degree assault, and fourth-degree assault, and that's all on Mr. Ali or Hassan, right? And then we have Zahraa's charges: Mrs. Ali, attempted second-degree M, attempted first-degree kidnapping, attempted second-degree kidnapping, second-degree assault, and second-degree burglary. Now, that burglary charge I know has been confusing some of you in that, and it confused me at first too until I heard it like 10 times. There's two parts of burglary. It's you have to be on a property, and then you have to commit a crime. So she was on the property unlawfully. They had a restraining order against her, protective order against her, and she went onto the property, and then she also went into the school to get Fatima. So that's why she's charged with the burglary. All right, let me just go back. Here. I don't want live court to come back and we miss it. Something's going on outside. So let's see. Okay, so she just kind of goes through all the different counts, so which we just kind of saw. And then we took a vote. Did the state prove their case for Mr. Ali only, for Mrs. Ali only, both or neither. So out of 919 votes, so thank you for voting, 73% of you thought the state did prove their case for both. So 73% of you thought the state proved their case. 21% of you thought Mr. Ali only, and I know there's kind of been some chat going back and forth that the state definitely proved Mr. but not Mrs. 3% thought neither, and 0% thought Mrs. Ali only. So out of 919 votes, you thought that Mrs. Ali only. So by and far, you think both the state did prove for both. So the one thing that I want to talk about in her instructions was the violation of the court order. So that was the burglary second degree count 4. So a person enters or remains unlawfully on a premises. That person unlawfully goes into a building. Then she defines what a premises is, and it's the violation of the court order, and it's she knowingly violated it. So they have to prove A. So this is count 5. A court order existed. B, she knew about it. Well, I guess 1, 2, 3, she knowingly violated that, and then 4, it was in the state of Washington. And I know some of you were like, well, so if it happened in, Vermont, would she be not guilty? Probably, because you have to state the state. You have to say what the state is. Let's see. No, as we found out, D3K2, I think it's only burglary if they determine she assaulted. No, you have to be if you're committing a crime. She had a court order against her, so she knew that she should not have been on that, and she went on to that. So as I just read, the violation of a court order. So 1, order existed, she knew about that. 3, she knowingly violated it, and 4, it was in the state of Washington. So she did commit a crime, but B, she committed a crime by violating the order, the protection order, and then she violated it even further because she did a crime by, as the state is saying, trying to choke her daughter out. So she violated that court order. Then they talk about let's see, if guilty, then you go to BBB. She was going through all these the verdict forms. So for Ihsan, for Mr. Ali, assault in the first degree, form B. Guilty, you don't go on to BB. If not guilty, then you go on to assault in the second degree. So, and then she was saying, if guilty, you don't go on to BBB, but if not guilty on that crime, then you go on to assault in the fourth degree. So they have all these varying levels of degrees of which they're going to have to determine. And then closing arguments. So she said there's 11 different crimes to go through. Do I have 11 crimes? Do I have 11 here? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. I have 12. So she said 11 crimes. I have 12. Huh. I wonder why she said 11 crimes. Oh, wait. I'm sorry. 1, 2, 3, 4, 5. Okay, Mr. Ali only has 5. He doesn't have the burglary. That's what it is. Right? Attempted, second degree, first degree kidnapping, second degree assault. Hold on a second. 1, 2, 3. There's 5, 6, 7, 8, 9, 10. Oh, I only have 10. So there's an 11th one in there. I don't even know what the 11th one is. So I'm missing a charge. All right, I'm missing a charge there. She said 11 charges, so I'm missing one. All right. So she has 11 charges to go through. So then she's talking about the overlapping with the parents. I guess I could come back here. We could watch. We could do this. So she talks about count 1, attempted M in the second degree. Let me just make sure I got these right. So count 1, attempted M in the second degree. She talks about the intent with a substantial step in the commission of the crime. We heard that in Carlos Dominguez too. The jury got kind of hung up on that substantial step. She grabs Fatima by the hoodie. She puts her in a chokehold. She takes her to the ground and she holds her there for, I'm sorry, this is all he. Sorry. So Mr. Ali grabs Fatima by the hoodie, puts her in a chokehold, takes her to the ground, holds her there for a prolonged time. And then she talks about Josh Wagner testimony that Mrs. Ali was choking Fatima. She was not hugging her. And then they talk about the accomplice. That's why currently I have a poll up there right now. Was Mrs. Ali an accomplice? So was she an accomplice to all of this? So Mrs. Ali arrives. They talk about this tree. Josh Wagner is still on the street. So she's there first. She's assessing the situation. She's there first. You see Isaiah struggling with Mr. Ali. She's bent down with arms outstretched, and Josh is just getting to the group. So she's basically keeping the kids from beating her husband, which is understandable. What makes it worse is that she's not helping Fatima. So it's one thing to want to help your husband who's getting pummeled by these students. And then it's another thing to be like, well, A, why is he being pummeled by these students? B, why are you not helping your daughter who is being choked by your husband? So he's getting pummeled by these students because he's choking out Fatima. So, it's like kind of like this, you're trying to help your husband, but he's in the middle of committing a crime. So you're not really helping your daughter out, right? So she's bent down with arms stretched. Josh is just getting to the group. Even Josh's wife, Mary, testified Zahraa was not helping Fatima. Mom is actively strangling Fatima. She has full view of the situation. She sees what's going on. And then she's about to get into count 3, which is unlawful imprisonment. I missed count 2. What was count 2? Count 2 is first degree kidnapping. All right. I guess I didn't really hear much about count 2. I didn't hear her really say much about the kidnapping. All right, I wanted to get to Josh's testimony, only because you guys were asking what he is. He was definitely in the military. He was what was he? He was Army. So he was a mechanic. He was in special ops. So Josh Wagner and Mary Wagner, if you remember, they were the couple that just came back from his birthday lunch, and they're driving by, and he sees this group of kids fighting, and he thinks, oh, it's some kids fighting, and he sees it's not an even fight. So he gets out, and he was in special ops. He was in the Army. He was a mechanic for special ops. So that's Josh Wagner's deal. He was an Army Ranger. Is that what? I didn't catch that, Snowcat. I just had he was special ops. But you heard he was a Ranger. Yeah. Vice says she jumped in and choked her too. Yeah, no help. Shame on her. Seems like it. Gina says a healthy mother prioritizes the child. Seems like it. Yep, I agree. Not a Ranger. I didn't catch he was a Ranger either, but if somebody knows some information, I did not hear that in his testimony. I just have he was in special ops and he was a mechanic. That's all I have. Special ops in Army is Ranger. Okay. Thank you. I didn't know that. Janet says there are definitely heroes in this story. Yeah, for sure. Sally, your boss keeps interrupting you, so you miss some of the closing. Hate when work interferes with your social life. I know, right? All right, we have difference of opinions here. He was a mechanic in special ops unit, not a Ranger. That's my notes. I don't know what that means. You guys, respectfully figure that out. All I know is he said he was a mechanic. He was in the Army. He was in special ops. That's all I know. I don't know anything else beyond that. I'm not an Army, not knowledgeable in that. What's up, Charles? Thank you for joining us. Lily Wayne, didn't Fatima say her mother wouldn't hurt her? I think so. I think I'm going to play once we hit verdict watch. I'm going to start playing her testimony again. So we will definitely check out her testimony. Yes, Aussie Gardner, thank you for the reminder. Thumbs up, people. Please don't forget to hit the like button. I think she was, I think you're correct. I know she said her mom, she never got a hug from her mother. I know she said that. Remember that. So Army and Special Ops usually means Army Ranger. Okay. Yeah, I really don't know you guys. You guys sort that out. Again, be respectful to each other. Let's not battle over Special Ops and Army Rangers. But All my notes have is that he was in the Army, he was a mechanic, and he was in special ops. That's all I know. Wagner was in the Army for 13 years. We can double check that. He was in the Army. Did I catch how long he was in there for? 13 years. Yep, 13 years. You are correct. He was in the Army for 13 years. Antoine. And Antoni? I'm not sure how to pronounce your name, sorry. But yes, you are correct. Her mother is not bonded with Fatima. She never gave her a hug. So, my 2 cents, why did the mom have a no trespass? Because she had been on the school property before and she was harassing Isaiah, Fatima's boyfriend. So the parents got a no contact order, a protective order. The school served it to Mrs. Ali, so she knew. She knew. Again, if he's a Buccaneer fan, I will take off 10 years, but I doubt he is. Selena K says, bottom line, he was the one that got him off of Fatima. Yes, yes, he did. Yes, he did. Northwest said, special ops units can be, not sure what SF, Rangers, PsyOps, Civil Affairs. Not all special ops units members are Ranger qualified. Thank you for that, Northwest. No shade on being a mechanic, very needed. Absolutely. Gotta have those, gotta have mechanics for sure. It's all part of the puzzle. You gotta have drivers, you gotta have mechanics, you gotta have, yeah, you gotta have everything. Jake Plain says, man, you are good people here. Very informative also. Jake, we try to educate. If you have information, drop it. You know, we are all about education. We want our chat to be educated, informed, and we don't know everything, that's for sure. So please, if you have information, please let us know. Oh, Special Forces is SF? Gotcha. Thank you, Northwest. Petunia, yes, the sister was there. Why wasn't she charged? I don't think she was actively involved. She was there, but she didn't put hands on. I don't think she was taking video, but she didn't put hands on Fatima. So that's probably why she wasn't charged. She was just taking video. She didn't actually put hands on and become a part of it other than just Haneen, I think her name was, right? Isn't that her name, Haneen? Yeah, Haneen is 21, Nora is 19. And then they have two younger brothers, 6 and 3. So I'm pretty sure it was Haneen. Was it either Haneen or Nora that was there? So she didn't put hands on Fatima, so that's probably why there was no charges. I'm only guessing. But if you guys haven't voted yet, please take a moment to vote in our poll. We have a poll. Was Mrs. Ali an accomplice? Yes or no? So take a moment. So Haneen is the one that, yeah. So there's Haneen and then there's Nora. Lynn, welcome to Rabbit Ears. Thank you. Retired defense attorney. All right, interesting. Please, if you have, and you're from South Africa, please, if you have any information, please feel free to educate us as well. We love it when we have lawyers in our chat. I know Richard in the kitchen, I believe, is also one. Please, if I misspoke, Richard, please help me out if I did. D3K2, was Haneen the one reading the trespass order? Yes. Yes, she was. Jenny saying, welcome in, retired defense attorney, Lynn. Short Life, so good to see you. I thought she testified she didn't want to believe she would hurt her. There's a difference there. I have to double check that, Short Life. Let me check. Well, I'll replay her testimony once we get into verdict watch. So I don't quite remember how, I don't quite remember what she, oh, they're back.
Thank you.
Please be seated. Ms. Stone, you may continue with your closing argument.
So now we've moved on to count 3. We're going to skip count 2 for Mr. Ali. We're going to come back to that. As you can see in your instructions, there's some other instructions that follow along with that. So let's skip over to count 3 first. That applies to both Ihsan and Zahraa, and that is the unlawful imprisonment of Fatima. So you have the instruction that tells you what unlawful imprisonment is, how unlawful imprisonment is defined. I've highlighted for you the intent element, which is knowingly. A person commits that crime when he or she knowingly restrains the movements of another person in a manner that substantially interferes with the other person's liberty. If the restraint is without legal authority, or without the person's consent, and the person knows that restraint is without legal authority, and without the other person's consent. What is restraint? Restraint is without consent if it is accomplished by physical force, intimidation, or deception. You have that definition in your packet. I'll tell you, I don't recall what the number is. For those, I don't have them all committed to memory. And then you have knowledge, what knowledge is described for you. Throughout the course of your instructions, you have a number of different intent elements that are described for you, or mental states that are described for you. Knowledge, intention, doing something with intent, and as you'll see later, reckless. Okay? A person acts knowingly when he or she is aware of that fact, circumstance, or result. You don't have to know that the thing you're doing is a crime by NRCW. You have to know that the thing you are doing is the thing that you are doing. You are acting with knowledge that you are doing the act. If I walked over here and pushed Miss Zoe, I don't have to know that that is a particular type of an assault. I have to know that I am pushing Miss Zoe, right? If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. And when acting knowingly as to an element is required to establish the element of the crime, that element is also established if that person acts intentionally. So if I walked over here and shoved Miss Zoe, I know that I have to know that I've shoved her, right? Not like I tripped or somebody bumped into me and I had no idea that I actually bumped her or pushed her at the same time. If I walked up and 2 hands shoved her, if you agreed that I did that intentionally, then you also agree that I've done that knowingly. Intentionally is essentially one mental element higher than knowingly. So as it pertains to Ihsan Ali, that is your to convict instruction, count 3. You have that in your packet, and we're going to come back to these. And then you have the same instruction for Zahraa, exactly the same, except again it has for Zahraa that principal or accomplice language. That is the only difference between those 2 instructions in your packet. Okay? So again, those elements as it applies to both parents. Remember I said that we are going to talk about what overlaps between them first. So what applies for both, don't anticipate that there is going to be an objection, or not an objection, a disagreement by defense counsel that's happened on October 18th, 2024. I also don't anticipate that there is going to be a disagreement. Again, you still have to find that I have proven it to you, but that the defendant knowingly, and as to this element, restrained the movements of Fatima in a manner that substantially interfered with her liberty. You have to find it, but I don't think the parties disagree that Fatima's movements were restrained. Ihsan strangles Fatima. She's unable to get away without help. Zahraa holds on to Fatima after, strangles her, would not let her go. Again, Fatima is unable to get away without assistance. So I submit that these are not going to be issues that are going to be really in contention between the parties. That restraint, as it relates to both parents, that restraint was without Fatima's consent. That is the testimony of everyone. She is fleeing her house and her parents. She has run away. She has been actively avoiding her family all day. Exhibit 34, you see that she is trying to run from Dad. She is fighting Dad. You have exhibits 74, 75, 78, 77, 81. You see all of those injury photos, and we're going to look at them in a little bit, but they show all those scratch marks to her neck. And you heard the testimony. I believe it was Dr. Gilbert. It may have been Lisa Wall talking about she's clawing at Dad's arms, and you hear all of the students talk about that. Clawing at Dad's arms, trying to get him off of her neck. Clearly, that demonstrates a lack of consent by Fatima to be restrained, let alone restrained in that fashion. And then Fatima tells you too, she's trying to tell her mom to let her go. She is not consenting to her mom strangling her. She is not consenting to the manner in which her mom holds her. And I want to be clear, we're going to come back to it, or not come back to it, we're going to get to it in a little bit, because you have a parental discipline statute. State is not asserting that a parent cannot restrain their child. We know that that is the case, right? There are things that parents have to do to correct restrained children, but this is not one of them. So as you're starting with the initial baseline of whether this happens with Fatima's consent, it certainly does not. And you have ample evidence of that fact. And then you have exhibit. Mom is strangling Fatima around the neck at about 2 seconds in, grabs her again at about 8 seconds in. And you have those screenshots. It's far away. It is harder to see, I would submit, but it is there. The location of Mom's arms. You have that Fatima, you see her forward, and then you have her leg going up, and you see that she is being pulled backwards at about 6 seconds in. She is trying to get away. She is looking to Isaiah for help. Her balance is being pulled off, and that is Mom who is holding her at that point in Noah's video. Again, that applies to both parents, that the defendant knew that restraint was without Fatima's consent. That's the testimony of everyone. Her parents know that she does not want to be restrained by them, certainly. And all of that evidence is exactly the same. Not only was it without her consent, but that same evidence tells the parents that they know that it is without her consent. They're not under the mistaken belief that somehow she's okay with it. And that any of these acts occurred in the state of Washington, same information that you had previously. Okay? So what is the unlawful imprisonment as it relates to element 4 only for Ihsan? First and foremost, without legal authority. You cannot strangle your child to restrain them. It seems really obvious, but apparently it has to be spelled out. You cannot strangle your child to restrain them. Instruction 21 is the self-defense instruction for assault, but I submit to you it is instructive for explaining the limitation on parents' rights for either correcting or restraining your child. You forfeit your right to use parental discipline to restrain your child when you do so in this manner, when you strangle your child and impede their breathing. It should be obvious. The other examples given in that instruction, you can't burn your child, that should be obvious to correct them or restrain them. You can't throw your child. You can't cut your child. You can't punch your child with a closed fist. Those should be really obvious things as parents, right? You do not, that force is incompatible with the duty to care for your child as a parent. So you cannot restrain your child by strangling them and cutting off their air. That is not an appropriate use of legal authority. And element 5, as it relates to Ihsan, that the defendant knew that restraint is without legal authority. He knows he's not allowed to strangle his child. You go back to that instruction 32, knowledge, subjective and objective components to knowledge. There's a subjective, he knows all the facts that what he is doing is not simply restraining her movements, right? It says, based on the facts and circumstances known to the person at the time, he knows he is not merely restraining her movements. Everybody there says it too, right? They're watching it. It's his arms around Fatima's neck. That objective measurement, if a reasonable person in the same situation would believe that fact to exist, then you are permitted but not required to find that he acted with knowledge. A reasonable person, I submit to you, with all of those same facts and circumstances known to Ihsan at the time, knew that restraining her in that manner was not with legal authority. There's no good faith belief here that such use is reasonable or moderate. And the law does not require you to know that that act is unlawful specifically or an element of a crime. It doesn't require you to go to an RCW or a jury instruction element 5 and say, well, I didn't know it was that element, so therefore you can't hold me accountable. That would be absurd, right? You have to know that the behavior itself is wrong and without legal authority. So how does that apply then to Zahraa? Again, same information. You can't strangle your child to restrain them. She watches Fatima being strangled by Ihsan. She then puts her own arms around Fatima's neck. She's not comforting her. She's strangling her to keep her from fleeing. Her breath is impeded. Fatima's breath is impeded by that hold. She testifies to that and told the medical professionals, you heard that from the professionals specifically, that she reported that by her mom to the medical professionals. You look at that instruction 21 and those limitations on what parents can do to their children to discipline or restrain them. She's doing it both herself as the principal, and she's continuing her husband's actions for that same purpose as an accomplice. That the defendant knew that restraint was without legal authority, that information is the same as it was for Ihsan. And then again, how do you know that she knows that that's without legal authority? Her own statements. Her statements are about how people have treated Ihsan at the scene. She has talked about, where is my daughter? Give my daughter back. I want to see my daughter. And I want to see my daughter. I want to talk to my daughter. Right? Her focus consistently is on Ihsan. It's not on the health or care of her daughter. Just location and access to her. That is all she expresses to law enforcement. So same thing, family or household member. This is your verdict form, C1. No change to that. Exactly the same as the last one. So now we're going to go to Ihsan Ali, count 2. And now that's the overlap between the two parents. Now we go to separate crimes for each of the parents. And we're going to start with count 2 for Ihsan Ali. That is that assault in the first degree. Assault in the first degree, the crime of assault when with intent to inflict great bodily harm. He or she assaults another by any force or means likely to produce great bodily harm or death. And then you have the definition of assault. We'll come back to that. That will apply when we get to the assault on Isaiah. Touching or striking, harmful or offensive. Right? Great bodily harm. A great bodily harm that creates a probability of death. Bodily injury that creates a probability of death or significant permanent disfigurement or causes significant permanent loss or impairment of the function of any bodily part or organ, right? If you take somebody's eye, you're talking about great bodily harm, as an example. Or if you use a measure of force that creates the probability of death if that force is not then otherwise interrupted. And that's what we're focusing on in this case. So you have those definitions, you have the overall elements, you're given that in your packet. There's 4 elements. So let's go through them. Well, we're going to talk about this first, actually. Physical discipline of a child that the force used was lawful as defined. We just kind of went through that. That force is lawful when it is reasonable and moderate, when it is inflicted by a parent for purposes of restraining or correcting. And you must determine whether the force used when viewed objectively as a reasonable person looking at that same force, is that force reasonable and moderate? And that definition goes on, as I said, things that the law identifies as that you may consider unreasonable. Striking a child with a closed fist, interfering with a child's breathing. The other examples we talked about, burning, throwing a child, kicking a child, all of those things. As part of your determination of whether force used was reasonable or moderate, you shall consider the size, age, condition of the child, the location of the injury. Certainly the smaller the person, the younger the child, the more concern there is for how that force is used on that child. It's not a binding inference, right? But that is an example of things that you can determine are. So that element, as it pertains to Ihsan, again, the things that I submit to you are not going to be in contention between the parties, right? October 18th, it's Fatima Ali and State of Washington. Those are not facts that people I submit are going to be arguing with you. Element 2 is where I think you're going to be focusing the majority of your discussion in this case as to this issue. So let's talk about the evidence that you have. Element 2, that it's committed by a force or means likely to produce great bodily harm or death. So first you heard from Lisa Wall, and you're going to see LOC because I run out of room in each of these, right? Loss of consciousness. What happens when you lose consciousness? Your muscles relax, the damage becomes easier to inflict, and the easier the damage is to inflict, the result is death. That is the next logical step following loss of consciousness, is death in that process. You have the exhibits from Synovia Rivas, 67 through 81. She talks about the symptoms that she observed immediately afterward during that exam: headache, dizziness, lightheadedness, again, loss of consciousness, memory loss, a fuzzy feeling. Fatima reported feeling fuzzy, confusion, weakness and numbness, vision changes. She says everything got dark, and you heard her talk about that. Hearing changes. She had ringing in her ears. She had neck pain, external neck pain, and you see all the bruising from that. You hear her talk about her sore throat, her difficulty and pain swallowing, those voice changes, the hoarseness. They describe her as hyperventilating. She was still hyperventilating after the fact. All the redness, abrasions, and bruising, and then the petechia around the eye that she describes. Fatima described a 5 out of 5 for pain, told Ms. Rivas she thought she was going to die, and it felt like it went on for 5 minutes. It felt really long. She said, I'm sure it wasn't, I know it wasn't, but it felt really long from where she was. And think about what Dr. Gilbert, when Dr. Gilbert went through and talked to you about what the effects were of jugular vein occlusion, carotid artery occlusion, tracheal occlusion. She correlated all of that to those symptoms specifically. Why do you get headaches? Because you have that buildup of pressure, right, in your brain. Why do you have loss of consciousness? Because there's not oxygen going to the brain, right? There's not bad blood coming out, there's not good blood going in. Why do you have memory loss or fuzzy feeling? Because all of that brain function has been interrupted as that process goes. She talked about the eye changes and the hearing changes because your brain stem is interrupted, and the ability for your brain stem to process and connect to the vision in the eyes is been interrupted and is unable to do so. Hyperventilating, you talked about panic. One of the natural symptoms, your body's natural reaction is to panic when it can't breathe. And that panic continues on until it no longer feels like it is in threat or fear. She's describing hyperventilating to synovia brevis while she's arriving at the hospital, still after the fact. She has not come down yet. Her brain has not taken that threat away so that her breathing has returned back to normal. Dr. Gilbert talked about all of those things. So then you heard also by the force or means likely to produce great bodily harm, you heard from Dr. Kim, who was not excited to testify, right? He talked about that. It was terrifying for him. But an otolaryngologist, I'm sure I am mispronouncing that. He's a specialist at that point, called in by St. Pete's, right? Strangulation can result in death. This seems to be a very accepted premise. Strangulation can result in death, not one really for argument. He says that there was air in the esophagus. They didn't scope it because they were worried that there was a tear in the esophagus, so they're not going to put a scope down there and increase that danger. That air is from damage to the throat, not from compression to the chest, not because she fell down and people landed on her. That's not where that happens. That happens below. And the air that he saw was higher up in the throat area. He said it's better in 24 hours, but he can't say it's gone. Remember what he said? Like, it had not gotten worse, but it wasn't gone. And he can't say it's gone because we don't do that kind of exam for that. We don't want to put that much radiation into this very small 17-year-old. Dr. Stankus is an ER doctor. She testified for the defense. She said pneumo mediastinum. She agreed. It can certainly result from strangulation. She agrees that the standard of care for pneumo mediastinum, the air that was higher up in the chest, to admit the hospital for observation and retesting, we don't send those folks home, right? It's not benign. It's not a mole. That was her example of something benign. We don't send those folks home. If you present with pneumomediastinum, especially as the result of strangulation, you're getting admitted, and we're going to watch you because it absolutely is dangerous. And Dr. Kim said, I had significant concerns. We were worried about her. That's why we admitted her. And Dr. Stankus agrees. Strangulation can result in death. Then you have Dr. Gilbert's testimony, and she talked about being a child abuse specialist and a 30-year medical practice. And she gave all of those strangulation effects on the body that we've previously talked about. She talked about that jugular vein occlusion. Remember, 4 pounds. That's that lack of ability to remove the deoxygenated blood. 4 pounds of pressure. It takes about a minute to lose consciousness with jugular vein occlusion only. 20 to 30 seconds for petechia, 3 to 4 minutes for death, if there is only jugular vein occlusion. Carotid artery occlusion, slightly different. Greater pressure required for carotid artery occlusion. 11 pounds of pressure, you lose consciousness in 20 to 30 seconds. Death is anywhere from 1 to 3 minutes. It's a range, right? You can't say specifically, but it's a range. And she talks about that. She said when a carotid artery occlusion, you're going to see a more global result. You're going to see loss of consciousness. You may see seizures. Then you move to brain death or death and a loss of muscle tone. When Dr. Gilbert watches that video, she says, I believe that I see a seizure. There's a moment right after or right before she loses consciousness that her arms, I believe she says, flail without any movement. And prior to that, there's some significantly focused intentional movement. And then there's a moment of flailing, and then she goes limp. Fatima goes limp. Caleb says, that's the word he uses. Isaiah uses, she frizzed, and then she went limp. So what are those kids describing to you? They're describing a difference between the moments where she is fighting, Fatima is fighting for her life, right before she loses consciousness. And I submit to you that is a seizure. And that is what Dr. Gilbert watches that video and believes she sees. She said, we can't test for it. That's not the kind of testing that we're able to do, but I submit that's what I see. And that is consistent with what the science says. It's consistent with what the witnesses observe. So how do we know that we've gotten to the carotid artery occlusion? Because about 30 seconds in that 20 to 30 second range, when you watch the video, That is when Fatima loses consciousness. So we know we don't have solely jugular occlusion. We also have carotid artery occlusion. He is imposing enough force on that child's neck to create significant damage, great bodily harm, and the likelihood of death, but for the interruption. And that death can happen in 1 to 3 minutes. Tracheal occlusion results in the lack of oxygen to the brain, that buildup of pressure. And again, Dr. Gilbert describes there's going to be immediate panic. You've got that CO2 buildup that's telling your brain that you have to breathe, and then it results in death. She describes observing the pneumomediastinum, the subcutaneous emphysema, that air in the throat, and anytime there's obstruction of either blood or air to the brain, it is a life-threatening injury. So Exhibit 72 and 103, the petechia described, you have synovia rivus on the left-hand side, and how do you know that it's petechia? Because it doesn't exist a couple of days later. 3 days later, it has resolved itself in Exhibit 103, and that is the distinction right between those two. October 21st, the photos show the bruising and scratches that cover from the left to the right side of her neck, consistent with the arm placement and pressure for her carotid artery, her jugular vein, and that tracheal occlusion. And you see that all in that space right there. Again, Exhibit 74, same, these are 3 days later. The bruising and the scratch is consistent to the front of her neck, where Fatima is scratching and clawing at her dad's arm to get it off of the front of her neck. That's the tracheal occlusion happening there at the front. Remember, your carotid and your jugular are on the side, and your trachea runs right down the center. Exhibit 81, the side of her neck, and that bruising goes all the way over to the back side of her neck. Again, consistent with the arm hold that is described by all of the witnesses leading up to that point, right? All of this bruising is the result of that, and that right arm and left hand in a chokehold from behind, and pressure for the carotid artery and jugular vein occlusion. So then element 2, again, force or means to produce bodily harm or death. Those symptoms reported in that video evidence tells us, based on the time and those symptoms experienced, that all 3 of those occurred in this case, which means the amount of time it takes to inflict the probability of death is grossly shorter. The force used would have resulted in great bodily harm or death if not interrupted. No injuries to her head are noted by medical staff or reported by her. Defense counsel, I believe in his cross-examination, said, well, if they hit that tree, couldn't this have happened? Couldn't this have happened? What if all of those symptoms are consistent with a head bump? And Dr. Gilbert said, some of them are. Not all of them, no, but some of them are. But also, I did a head to toe in none of those. There's no bumps on her head. There's no bruising. There's no tenderness. Plainly, there's no medical symptoms or science to indicate in any way that she struck her head. All of her injuries and damage is to her neck. All of the symptoms she experienced flow directly from that damage. And that's it. Element 3, acted with the intent to inflict great bodily harm. He is acting in anger for her defiance. That is intentional. That is what Ihsan Ali is doing. He holds her in a rear naked choke for just under a minute, and he is squeezing hard. He knows she is fighting. He knows she is struggling. He knows she is gasping for air. He knows that she is grabbing at his arms. And then she goes limp and stops fighting. But despite that, he continues to strangle her. So you know he is acting with that intent. He's ignoring the strikes and the screams of the kids. They are punching, they are kicking, and it has zero effect. It does not impact or change his behavior in any way. And that is an extended period of time. We know that he already has his arms, in fact, around her neck when they go down to the ground, and he doesn't throw his arms out to catch himself. He's going down with her, and he's going to hold on to her neck no matter what happens to her in that process. From the beginning to the end, because at the point that he grabs her by the neck, he is furious. And that is what he's acting with the intent with. It's not to restrain her, it's not to do any of those things. He is now just a grown man strangling a child because he is angry that she has defied him. He's only released Fatima when he is forced to do so by other adults. When you go back to that family household member, that is your B1 special verdict form again, nothing has changed. Back to physical discipline, that force used is lawful is defined, reasonable and moderate, purpose of restraining or correcting, and viewed objectively. So why does this not apply? Well, it applies for charged and lesser offenses. You're going to see that, and you have a whole range of instructions in there about lesser offenses. First, it must be your child. Okay, he meets that. It's his child. It's not somebody else's child. Must be for the purpose of restraining or correcting. It fails immediately there. None of this contact at this point for the assault in the first degree is for restraining or correcting. It is punishment. He's intending it for punishment of this child. Ihsan is angry. He may have gone to the bus stop to get Fatima and take her home, but by the time he grabs her, he is no longer doing that for the purpose of correcting her. I think one of the primary tenets of parenting is that if you are so angry you can't see straight, you do not engage with your child. You walk away. You don't attempt restraint. You don't attempt correction, because you are no longer acting in a manner that is for the child's purpose. By the time you make contact with that child, you are doing so for your own edification. That's exactly what is happening here. Parents don't correct children by strangling them. Parents don't correct children, restrain children by strangling them. It has to be objectively reasonable and moderate. You are deemed to be reasonable people. That's why you're sitting here. It has to be objectively reasonable and moderate use of force, and that is not what occurs in this case. It is unreasonable to strike a child with a closed fist or interfere with their breathing. The medical evidence proves that his acts interfered with her breathing. You have to consider the size, age, and condition. We heard that Fatima's 5'1", 100 pounds, maybe soaking wet. She's a small person. She might be 17 years old, but she's a small 17. And she is certainly grossly smaller than her father. We also heard the testimony of Tracy Arnold. This day occurred. Remember, Fatima's been home, being online. She's not been at school since about September 17th, so they haven't seen her in about a month. And Tracy Arnold, and she looked thinner, way thinner than the last time I saw her, and much more frail. So I submit to you that Fatima is particularly vulnerable. She already was with her size, but even now more so than she was just 4 weeks prior. And we also know that Fatima's throat is particularly vulnerable as a child. Dr. Stankus' testimony on behalf of defense also said, children obviously are smaller. It's easier to do damage to their windpipes. It's easier to do damage to their necks. She might be 17 again, but she is a small 17, and as a child, she is already more vulnerable than, say, an adult male, right? That placement of that force is extremely dangerous for those jugular veins, the carotid arteries, the trachea, and the spinal cord in the back of the neck, and all of the medical folks talked about that. You have an instruction in there that is very wordy, because again, we're lawyers and that's how we put things in a narrative. But I'm giving you a picture, okay? You start with assault in the first degree. That is what you evaluate first. You do not move on to any other instruction and evaluate it until you have completed assault in the first degree. If you have evaluated and deliberated on assault in the first degree and you agree unanimously that he is guilty of assault in the first degree, you stop. You don't address assault 2, you don't address assault 4, you stop. Your inquiry is done. If you're like, man, I don't know, then on assault 1, then you move over. Whether it's unanimously not guilty or you're unable to reach a verdict, then you go to assault 2 and you start that process over again. I will tell you that as you go through, you may well say to yourself, well, these two are easy, these two are really obvious, we'll just do those instead. You don't get to. Your instruction says you do assault 1 all the way first, and then if you are unable to complete that, then you move to the other 2. You work your way down, right? But otherwise, your inquiry stops if you all agree unanimously that he is guilty of assault in the first degree. Same thing. Do not begin that analysis until you've reached a decision on assault in the first degree. So then we go to assault in the second degree, that lesser included. When someone intentionally assaults, as it relates to Ihsan, when the defendant intentionally assaults another and thereby recklessly inflicts substantial bodily harm, or assaults another by strangulation. You now have the definition of reckless, knows of and disregards a substantial risk, and that disregarding is a gross deviation from conduct a reasonable person would exercise in the same situation. And I'm going to show you a ladder here, that mental elements ladder. So remember, we talked about if you do something intentionally, then you've done it knowingly. If you've done it knowingly, then you've done it recklessly. So it's when recklessness as to a particular fact is required to establish element, it is also established if a person acts intentionally or knowingly as to that fact, right? And that makes sense, because if somebody has disregarded a standard of behavior that is expected, and that is a gross deviation, then we presume that you did so knowingly. I'm sorry, if you've done so intentionally and knowingly, then we presume that you've also done so recklessly, right? It's incorporated therein. So substantial bodily harm, a temporary but substantial loss or impairment of any bodily part or function, or a fracture. And then you have the definition of strangulation: to compress a person's neck, obstruct the person's blood flow or ability to breathe, or do so with the intent to obstruct the person's blood flow or ability to breathe. It's a really obvious, I submit, definition, but we have to give it to you anyway. So count 2, assault in the second degree. These are your definitions. We'll come back to the bottom paragraph, but you essentially have to decide A or B, 1A or B, and you don't have to be unanimous about 1A. So as it applies, same information for October 18th, 2024 in the state of Washington. None of that has changed. So 1A, intentionally assaulted. There are 2 ways that Ihsan Ali could have done this under the assault in the second degree. 1A, he intentionally assaulted and thereby recklessly inflicted substantial bodily harm. So the evidence you have of the intentionally grabs her twice. This is not an accident. He grabs her the first time and then he grabs her the second time. That moves into that rear naked choke with sustained pressure. Kids are pulling so hard that they have to dislodge him, that they have ripped his jacket. And regardless, he maintains his hold throughout. That is intentionality. Can't breathe is a temporary but substantial impairment. Losing consciousness is a temporary but substantial impairment of any organ or function. If you cannot breathe, if you have cut off air to the jugular veins and the carotid artery, blood flow, jugular veins and carotid artery, you have temporarily but substantially impaired their ability to function in the way that they are supposed to. If you have cut off the airflow because you have crushed the trachea or closed the trachea off so that air can't get through, that is a temporary but substantial impairment because that bodily organ cannot function. If you have lost consciousness, your brain is not working the way it is supposed to. It is a temporary, even if you regain it, but substantial impairment because you are intended to stay conscious. That is what your brain is supposed to do, and his behaviors have impacted her ability to do so. Sore pain, painful throat, difficulty swallowing that she describes well after the fact, temporary but substantial impairment, those changes to her voice, those changes to her motor skills, her ability to get up and move around. You heard that described, that loss of muscle tone, temporary but substantial impairment, and then you have all of that bruising along her neck. By definition, that is temporary but substantial disfigurement. That is not how she appeared prior to, and we're looking at 3 days later and it's scratches and that bruising is still there, those abrasions. So then strangulation, 1B, Exhibit 34. You see him grabs at her neck twice. It's not an accident and refuses to release. You see, again, that sustained pressure. A lot of that information is the same for strangulation as it was for 1A. You have that her face changes color. You have all of that bruising. And you have the medical reports and the nurse's testimony. And you have that she can't breathe. Again, doctor reports, nurse testimony, and medical reports. So all of that information is the same for 1B. You're going to consistently have overlap in the evidence between many of your charges. When you go to do that evaluation, you have to all unanimously agree that either 1A or 1B occurred. You do not have to agree which of 1A or 1B it is to find that element number 1 has been met beyond a reasonable doubt. Okay? And then BB1, family household member, again, exactly the same. When we talk about count 2, as it separates itself, the lesser included for assault in the second degree from assault in the first degree, the initial placement of dad's arms around his daughter's neck and the impediment to her breath, that strangulation is complete. That's it. Assault second is done. As soon as he puts his arms, there's no requirement for loss of consciousness. There's no requirement for any of these other things to do. For strangulation, all he has to do is impede her breath. And the moment he puts his arms around her neck, and you see her standing there grabbing at them before they've even gone to the ground, assault in the second degree is completed. That extended hold of her neck is what distinguishes assault in the first degree from that assault in the second degree. That is why that is not merely assault in the second degree. It is also, but it is not merely. So that's where we were. Back to your roadmap again. If for some reason you're stuck on assault in the second degree, then you go back through that same process. If it's guilty, you stop. If it's not guilty, unanimously, or you are unable to reach a unanimous verdict as to assault 2, then you go to assault in the fourth degree. So there's that definition for assault in the fourth degree. It's simply committing an assault. No bodily injury required whatsoever. Nothing changes for counts 1 and elements 1 and 2. And the back half of element 1 then, as it relates to Ihsan, simply that he assaulted Fatima Ali. The touching is harmful. We have all of that testimony of the parents, of those present, the kids, Mr. Denicola, the Wagners, all of the doctor and the medical. And then we have that the touching of Fatima is offensive. She's fighting it. She clearly doesn't want to be touched like that, like how he is touching her. There's no injury required for assault in the fourth degree. So yes, obviously assault in the fourth degree has been met by the evidence before you in this case. And then BBB 1, that's your family household special verdict form again. And that's where you end up. So last count for dad, assault in the fourth degree as it relates to Isaiah. What that definition is, we talked about those elements. They are exactly the same as that lesser included was for Fatima, but now it is for Isaiah. We all are likely to agree that none of this information has changed and is not at issue in this case. It is October 18th. That is Isaiah Williams, state of Washington. So what evidence do you have about the assault 4 of Isaiah? That touching of Isaiah is harmful. You have the video of Ihsan punching Isaiah earlier in Exhibit 34. You have those still shots from Exhibits 8 and 9. 8 and 9 of him punching Isaiah in the head. Not simply a shove, not simply a push, but a closed fist punch to the side of Isaiah, his temple. And then you have the exhibits 39 to 51 showing his injuries, that redness, the bump, the pain. You have Officer Beltran described seeing that in person and taking those photos. And you have that testimony. And also, you saw Isaiah. It's physically much, much smaller than Ihsan. And you saw him when he was present here, and you see him in the video. They are not the same size individuals, right? And you know that touching is offensive. First of all, I submit to you punching anyone in the head, unless you are engaged in a boxing match, which you've signed up for, is offensive, right? Punching a child in the head is particularly offensive. Notably, no injury is required, but it exists here. There is that bump, that redness and that swelling and that bump to the side of Isaiah's head. And you see it there, consistent with where he says he is struck and with where you see Exhibit 51, that closed fist strikes him in that bus video. So then you also have the self-defense instruction that is given to you for Ihsan, saying, well, I'm forced essentially to do this, and the state has to disprove that. So as it relates to count 4, force used by a person who reasonably believes he is about to be injured and the force he uses is not more than necessary. The person using the force may employ such force and means as a reasonably prudent person would use under the same or similar conditions as they appeared to the person, taking into consideration all of those facts and circumstances known to the person at the time of and prior to the incident. Then you have a definition for necessary, as they reasonably appeared to the actor at the time. Not as he claims that they appeared or he'd like them to have been, but as they actually reasonably appeared. That there's no reasonable, effective alternative to the use of force and that the amount of force used was reasonable. And you have that in your definition. There's no duty to retreat, to be very clear. If somebody is attacking you, you are not required to retreat. But still, there is the requirement that the lawful force be not more than is necessary. You don't get to do whatever you want, plainly. There are limitations on what force you get to use in response. You also cannot be the person that physically instigates that interaction in order to create the likelihood of provoking a belligerent response from someone so that then you can use self-defense after the fact. And you have that instruction there as well. So why is this not self-defense? Start first, that force is not lawful. He does not reasonably believe that he is about to be injured when he strikes Isaiah. He is not striking Isaiah to himself. That's not what he is doing. And you'll look at those photos and you'll look at that video again. He is striking Isaiah to prevent Isaiah from interfering any further in his mind with what he gets to do to Fatima. It is objectively unreasonable what he does to Isaiah. He is grabbed at the point that a strike hits, and you'll watch that video. He has already grabbed Fatima by the hoodie and he is dragging her by her neck into the dirt. And Isaiah's hand on him trying to pull him off. Isaiah's not striking him. Isaiah's literally trying to disengage Fatima from her dad, who has her by her hoodie front collar and is pulling her forward. It is already choking. That has already started. That is an unreasonable means of restraining your child, I submit. And Isaiah said, he doesn't just like grab her like, let's go home. That's not what happens. He's like, he grabs her aggressively. And remember that Isaiah has known Fatima at this point for a couple of years. And he says, I know Fatima. I know what she goes through. And so he is anticipating that this is not simply a, let's go home and have a sit down family talk about it. He is concerned deeply for what might physically happen to Fatima. And almost immediately, when she's getting ready to go, Dad grabs her by that hoodie and starts dragging her. And Fatima says that. It is, as we saw from the parental discipline, our laws recognize that it is objectively unreasonable to throw, to strangle, or punch their own children with a closed fist, let alone someone else's child. And that's when we give more leeway to parents, right? If you look at that video, he's not striking, Isaiah is not striking Ihsan. The evidence does not support that finding. And we talked about the size of Ihsan compared to 16-year-old Isaiah, who is 5'5". He didn't know how much he weighed, but I submit to you, he's a pretty thin kid. He's not a big kid. And he's also not punching a grown man who is in the middle of throwing a punch at him. That force used by any objective standard is unreasonable. You heard Elijah describe thunk. He's like, I heard that thunk when it hit. He's punching Isaiah in the head with a closed fist. It's not okay to do that, especially not when and how that punch occurs. It is for the purpose of neutralizing Isaiah so he can get to Fatima. It's not for protecting himself. It is not self-defense. Ihsan has created this situation. Isaiah did not. Ihsan's intentional actions were reasonably likely, I submit to you, to provoke a belligerent response from those present. Isaiah to be closest and have the most background information. We talked about that. And from the get-go, Isaiah is trying to assist Fatima, who he believes to be in physical danger. And he's right? And notably, when you look at this self-defense instruction or defense of others, Isaiah is entitled to protection under the same legal principles. So if anyone is entitled to defend themselves, it would be Isaiah. Those strikes by Isaiah on Ihsan do not occur until Ihsan is already strangling Fatima on the ground. There's a lot of, well, he hit him like 42 or 32 times, whatever number defense counsel proffered. That doesn't happen until after the fact and they're already on the ground. Isaiah has not struck Ihsan when Ihsan punches him in the head. There is the initial, and you'll be able to watch it in Exhibit 5. There is the initial contact, and when you look at that video, when you look at those photos, you'll see he's already dragging. He already has a hold of Fatima by the front of her hoodie collar, which is what Fatima describes, and Isaiah is trying to pull them apart. And see, there's another example of Isaiah, Ihsan dragging Fatima by the front of her collar, and she is pulling back, and Isaiah is trying to dislodge them. Exhibit 6. You go to Exhibit 7. All he is doing here is, again, trying to get him to let go of his daughter, who he has by the front of her collar, and is throwing her on the ground. That is what Isaiah is doing during the course of this interaction. And now Fatima's down. He's thrown her on the ground, and look at what Isaiah and Ihsan are doing. Isaiah's hands are out. They're out in the, what are you doing, man? What is happening? Oh my gosh. His hands are down by his side and they are out. And what is Ihsan doing? He's grabbing him by the front of the collar, and then bam. And look at Ihsan's face. Does that look like the face of an individual who is protecting themselves? Or does that look like the face of a guy who's real angry? Real angry that this kid had the audacity to interfere with how he has decided he wants to parent his child. I submit to you that's exactly what that face is. That has nothing to do with protecting himself and everything to do with exerting his anger and his power and control over this other child that is present. He's not being attacked, he's being thwarted, and he's being interrupted, and he doesn't like it. It's happening because Ihsan is mad. The force he uses is neither reasonable nor is it moderate in this case. It is not a necessary use of force in either the timing of when it occurred to protect himself, nor is it a necessary amount or reasonable amount of force being used. So now we are at Zahraa Ali, count 2, assault in the second degree. That completes all of Ihsan's charges. We are done with Ihsan. We have hit a milestone. Element 2, pertaining to Zahraa Ali. The on or about October 18th, assaulted Fatima Ali by strangulation. When you look at this element itself, this count itself, you will note that there is only one type. Whereas with Ihsan assault in the second degree, we had 1A and 1B, we have those alternatives. For Zahraa, we only have strangulation. Again, October 18th, state of Washington, none of that changes. Intentionally assaulted, Exhibit 133. She intentionally grabs Fatima at the neck, not an accident. You have Noah's video that mom is holding Fatima around the neck at about 2 seconds, grabs it again in 8 seconds, and then those screenshots show that location of her arms, like we talked about before, that she's being pulled backwards. That strangulation for assault too, or those same behaviors, that is separate and apart. You also have that Fatima testifies she can't breathe. You heard Zayla Carter talk about how Fatima is trying to get up and run, and mom is grabbing her by the throat, and Fatima is pushing her away. Mom is not giving aid. Mom is not asking if she's okay. Zayla says she's just trying to grab her, and she's grabbing her by the throat. Athena immediately knows it's wrong, and she says so. Like, what are you doing? Mr. Leary asked her a question about whether it's mom or sister, and you remember you heard Athena go, it was mom, and then she goes, well, now that you're asking me and pointing the video, I'm not sure if I know if that's mom or sister, but she is correct. We know from the video it's Zahraa. Visible standing away from Fatima. So we know that Haneen never puts hands on Fatima. As far as the video shows, we know that it's Zahraa the whole time, and Athena is correct. So yeah, the child, again, got confused in terms of the direct examination questionings by Mr. Leary, but you watch the video and you know that she is right. She says, Mom grabs her by the throat, and I said, what are you doing? You can't do that, because she just watched it happen. Even Athena, who has no medical training whatsoever, knows that that is not proper, and Mom has done that. And she is correct. And then you have the testimony that Zahraa is she's holding on to her by the throat to both keep her from fleeing and to continue those efforts of Dad. And Fatima is fighting that as well. There's no indication by anything that we've seen in terms of evidence that somehow Zahraa is below average intelligence or has some sort of eyesight problem. Nothing that interferes with her ability to perceive what everyone else testifies about over and over and over again is clear and obvious. Even to Josh Wagner, who arrives after Zahraa is already on scene, right? She knows that her daughter is unconscious. She knows her daughter is injured because they were her arms helping to do it, and she doesn't ask if she's okay. Just let me talk to my daughter. Those are grossly different response, and you saw the video of that. It's a grossly different response for the arrest of her husband and the strangulation of her child. And let's be clear, the state's not saying that there is some sort of anticipated, expected response, that everybody's response to an emotional situation has to be a particular way or it has to be consistent. We know that that differs from person to person. But when we're talking about Zahraa's response for the arrest of her husband compared to the strangulation of her daughter are demonstrated by Zahraa on body cam to be grossly different. And then we have the strangulation, the medical reports, the doctor and nurse testimony. So the physical discipline defense for Zahraa is the same analysis as it was for Ihsan. It is unreasonable to interfere with a child's breathing. That is an inference that you get to make based on that description. Nothing changes about the size, age, and condition of the child. And nothing changes about the location of the injury to Fatima. And that's same special verdict form for assault in the second by Fatima, or for Zahraa on Fatima. Count 4, burglary in the second degree. Burglary in the second degree occurs when you commit the crime of entering or remaining unlawfully in a building with intent to commit a crime against a person or property therein. That's the definition. Then you have the definition of enter or remains unlawfully. That is again in your instruction packet. You enter or remain unlawfully in or upon premises when you are not then licensed, invited, or otherwise privileged to enter, so enter or remain. Guys, that also means that when somebody has trespassed you from what otherwise would be a public place, that means that you are no longer licensed, invited, or have the otherwise privilege to so enter and remain. Instruction number 44, a person who enters or remains unlawfully in a building may be inferred to have acted with intent to commit a crime or person therein. This inference is not binding, and you decide what weight, if any, to give it. That means the state does not have to also charge underlying offenses and also prove those beyond a reasonable doubt. You get to infer, if you so choose, as to the defendant acting with the intent to commit a crime or against person or property therein. And then there are your elements. October 18th, entering or remaining, state of Washington. This slide probably looks very familiar. Again, it doesn't change. Elements 1 and 3 happens on October 18th. It happens in the state of Washington. Backside of element 1. Unlawfully in a building. How do we get to the point where she is unlawfully in that building? You heard the testimony on September 16th. That incident occurs with Isaiah on campus. You hear that Celeste Walter corroborate that, and as a result, I trespassed Mrs. Ali from campus and all North Thurston School District property. You heard the testimony of Ms. Waltermeyer and Officer Howard on September 17th. Haneen comes to try and pick Fatima up early from school, and the school says she needs to stay and you need to tell your mom to come have a meeting with us. So later that afternoon, Zahraa returns. She meets with Celeste. She meets with Officer Howard in Celeste's office and is presented with that trespass order and those instructions about the order by Officer Howard. You have further that when Zahraa returns and they serve her with that trespass order and she's given those instructions, Officer Howard offers Zahraa the language line. And you heard what the language line is. The language line is, if you don't understand, the document that's been provided to you is in English. If you don't understand or you're not comfortable with that, we can provide you assistance. Would you like someone who speaks Arabic directly to be on the language line and have this conversation with us? You can choose to take it, you can choose not to take it, that's your choice. Zahraa declines the language line. She does not want the language line. Instead, she asks for Haneen to come assist. So Officer Howard and Celeste say, sure, we'll wait. So in the meantime, they're chit-chatting with her in English about a number of topics. And then Haneen, Zahraa's request, arrives and they go over the order a second time while Haneen is present and assisting. You hear the testimony that she's offered chances to ask questions. She has specifically identified to her the places she can and can't go. You can't go to the baseball fields. You can't go here. You can't come to the building. You can't come to pick up your daughter. It's fine for Ihsan to come pick up. It's fine for Haneen to come pick up. This only applies to you. You are not allowed to be on the property, period. She has a chance to ask all of those clarifying questions about the parameters. She's given the phone number to call if she has any further questions. Defense counsel said, well, there's nothing on there that says she can appeal that decision, right? There's not. There's no requirement. And you're not going to find it in your instructions anywhere. It doesn't exist. She is given a sheet that describes what she is to do. She is then orally advised twice with the interpreter of her choice. She speaks English, to be clear. It may not be her first language, but there are consistent interactions with English. No one's saying that her English is great, but it is certainly enough. You heard Fatima's testimony. They've lived in the United States since Fatima was 6, so we're at 11 years at this point. And Zahraa is able to communicate in English with these women, and she has done so consistently, and that is described. But even with that, she asks for Haneen to come, they wait for Haneen, and they go through all of this. And that phone number is pointed out and identified. Here, if you have further questions, then call this number. And per Ms. Waltermeyer, that never occurs. There's no questions about it. It is a clear, it is a self-explanatory order that is accompanied by oral explanation. And then you have that trespass letter itself at Exhibit 121. Then on October 18th, she violates that order. She enters or remains unlawfully in a building because she is not allowed to be in that building. You have that she arrives on campus, where she's already expressly been told not to be. She understands that. Moreover, Haneen, the person that had that conversation while she was present, is with her. So Haneen knows as well. She's not there by herself. Then when Fatima escapes her the stranglehold, she chases her into the main office, inside the school building, where she is not allowed to be. She not only goes into the building, she goes into the office and tries to continue to go through the back. And you heard Tracy Arnold say, I had closed those doors and I was using my weight to try and hold those doors closed because I could still hear her and Denise Kinley yelling back and forth. She then leaves, and you see her in the video try and go through the side doors, and Principal Dean cuts her off. Got that intent to commit a crime. The entering or remaining is with intent to commit a crime against a person or property therein. She knows husband of just strangled is in there. She has demonstrated at this point her ability to physically assault a child. She knows Isaiah. She chased them. She ran after them. And we've heard it over and over again. In her story, there's no evidence to support that whatsoever. If anything, Isaiah is a kid in the story that everybody would, I think, like to have as their kid. He is kind, he is respectful, he is there to help out friends and look for danger to people that he knows are particularly vulnerable, and he demonstrates that on the stand. But she blames him and his family for everything. I submit to you, you heard from Victor Barnes. Victor's Isaiah. Listen, we tried to engage. We tried to have a reasonable conversation. We tried to be respectful about what the parents wanted, what Ihsan expressed he wanted. And so we said, you guys can't see each other. You need to take a break, right? And he was not like over dramatic by any means. He said, I understand that parenting is hard, right? Everybody agrees that parenting is hard. I think everyone would agree that parenting teenagers is not for the faint of heart. It is difficult for sure. And we've talked about that at length. But this goes well beyond that. And Victor says, I understand it's difficult, but you know what? They're teenagers and they're in love, or they think they're in love at least. What are you going to do, right? So we put some boundaries on it, we put some guidelines on it, and it didn't pan out. And this was the response. And for Zahraa, that is all Isaiah's fault. That is his fault, his fault, his fault. And so what is she doing? She knows there's a no contact provision, so what is she doing when she goes in there and chasing him in? She knows she's violating that order, and she intends to violate that order. She knows she has that with Isaiah. She has to stay 1,000 feet away, and she knows that he is in there because she watched him go into that building. The intent to commit a crime against a person or property therein. Again, I don't have to prove, you don't have to find what crime the defendant acted with the intent to commit therein. That's not in your instructions, and you're not going to find it because it doesn't exist. It could be any number of them. A further assault of Fatima, an assault of Isaiah, a further violation of the no contact order with Isaiah. You must only determine that the entry remaining within the building was with the intent to commit a crime, but you need not actually identify that that crime has occurred. So there we know she's going in the building because she's actually in the building, right? Exhibit 110, page 6. We know she's in the office itself because there she is. Bottom heading towards those back doors. There's Tracy Arnold, exhibit 111, page 9, running through to try and get in front of her because as she said, when she closed those glass doors at the front of the office, main office, Mrs. Ali goes around her. And there she is yelling at Miss Kinley and arguing. Page 11. And still arguing with Paul Dean in front of that campus expectation sign. We know she's not allowed to be. Now, mind you, the burglary doesn't happen until she enters a building. The burglary itself is not for simply being in the parking lot or on the property. The burglary happens, in this case, when she enters the building because that is the definition. Okay? So just make sure you make that distinction. Last crime. We're almost there. Count 5, violation of that no contact order with Isaiah Williams. So violation of the court order. You commit the crime of violation of a court order when you knowingly know of the existence of the order and you knowingly violate one of the provisions that's identified within that order. And you have, again, that element instruction in your packet. 4 elements altogether. We're going to go through those elements with the evidence that you've seen for each of those elements. 1 and 4, seen this, same instruction, right? Don't anticipate argument or significant argument, but you still have to find that the state proved it, and you have to find the state proved it for each count that exists, okay? So the court, here's the order, Exhibit 36, page 1, that you have. You have the court that has issued that order. Well, let me go back up for 1 second. There existed a protection order. So let's look at the back half of element 1. Existed a protection order. Exhibit 36, page 1. You have the court that has issued that order, Superior Court of Washington, Thurston County. You have the protected person or the petitioner, Isaiah Williams. Isaiah is 16, so as a parent I have to petition on his behalf to protect him. You have Zahraa as the respondent. You have the effective date until October 24th at 9 a.m. And then you have this order restrains and then Zahraa Ali. So clearly identified as the restrained party. It's not an overly complicated order to read. Then you have section 3 on page 2. Protected minor is listed on section 3. There's your section 3 when you're looking for it right there underneath the red dot. And that order protects Isaiah Williams. Page 4, here are all of your provisions that she is restrained from doing and clearly outlined. No harm to Isaiah. and the minor listed in section 3 above. No contact with Isaiah or through a third person. No stalking of Isaiah, harassing, following, monitoring of Isaiah. You have the exclude and stay away by 1,000 feet from Isaiah, his school, himself directly there under D, element D. And then stay 1,000 feet away from the listed residents, and they put in their own listed residents specifically, because by that point they know, mom and dad already know where they live because they've shown up at the house, and you heard Victor talk about that, right? That he tried to reason with them, he tried to talk to them, he tried to avoid this, and he was unable to do so based on the way events had been unfolding because they showed up at his house. So the elements that the defendant knew of the existence of this order, you have Officer Hang's testimony that he serves that order on October 16th. Remember that it is issued, let's go back, it's issued October 14th. That's when the order is issued. 2 days later, Officer Hang serves that order. Exhibit 37, you have that proof of service that Hang files with the court. And then you have Exhibit 38, the body camera of that service. He serves it on Zahraa at her home. You watch that. You see that Haneen is with her at the time of the service. Again, at her request, Haneen says, "Can I stay? I help my mom." Yeah, sure. The two women are communicating with each other back and forth about that order as Hang is describing it. Zahraa asks questions about it herself in English of Officer Hang. Haneen also asks clarifying questions. You know they understand that Mrs. Ali, Zahraa Ali, understands what that order is because she demonstrates that. He in fact points out the number to call in the document if she has further questions. He explains it to her in basic terms. He doesn't use overly complicated terms, and it's not a complicated document or set of directives to comply with or understand how to comply with. Moreover, you see her ask that clarifying question. Wait, so if this means I can't contact him, does this mean he can't come to my house either? She understands what the limitations of that order are. Does that mean that if I'm here and he comes to my house, then he gets in trouble too? Well, what does Officer Hang say is, well, if he comes to your house, like you have a right to be in your home, you can call law enforcement if that's the case, right? We know she understands the order. She asked that clarifying question. She provides alternative situations and is trying to decide how that order, those alternative situations fit into this order. So we know she understands what the limitations of that order is. And she has, again, her chosen interpreter present with her, and she's communicating with her throughout. She doesn't demonstrate at any point that she doesn't understand how she is personally restrained, or demonstrate confusion about how she is personally restrained. And then you have element 3, the defendant knowingly violated that restraint provision, prohibiting contact, excluding the defendant from a school, prohibiting the defendant from knowingly coming within a specified distance of the location. So on October 18th at about 2:13 p.m., she's certainly within 1,000 feet of Isaiah. She's physically engaged with Isaiah, and then she chases him and her daughter into Timberline High School, certainly within 1,000 feet. And then you have it again at 2:13. She's in 1,000 feet of his school grounds itself. So there's 2 separate provisions that she has violated. And then she knows exactly some confusion about who Isaiah says his name. She tells Hang and Bell and Chavez, you see that in their body cameras. He goes to school here. She knows where Isaiah goes to school. He's a student here. Hanina just said, Isaiah James Williams. He's a student here, I'm pointing. Right? She knows exactly who is protected by that order. There's no confusion. She knows exactly where his school is. There is no confusion. She knows she's violating that provision of that order. She just doesn't care because it doesn't matter to her. She doesn't care. There's Exhibit 134. There's Isaiah. Before everybody starts running. There's Exhibit 108, page 2. There's Fatima and Isaiah. Zahraa right behind with Haneen behind her, certainly within 1,000 feet there, certainly on the school grounds, while Isaiah. Page 109 again, you have them running, and I believe that's at 2:20 of that video, of the 2-minute and 55-second video, again, you see Fatima and Isaiah. And at 2:41, 21 seconds later, you have Zahraa chasing after them. She's about 20 seconds behind them in her run, and certainly within 1,000 feet of Isaiah. So that is it. At the conclusion of all of your deliberation, I'm going to ask you to return verdicts of guilty on each of the charge counts and findings of yes for each of the special verdict forms for Ihsan and Zahraa Ali as the state has charged them. Thank you.
Members of the jury, at this time, the bailiffs will lead you back to the jury room. We anticipate a 30-minute break, but if you are not done eating lunch after 30 minutes, you tell the bailiff that, and we'll have a longer break. When we return, we will start with the closing arguments by Mr. Kading on behalf of Mr. Ali. Thank you for your time and attention. We're still just in this process. When you go back, all you're doing is eating lunch. All of my instructions as it relates to not discussing this case, not seeking out information and the like, that continues to apply. Thank you for your time and attention.
Well, she said 2 hours, and it was 2 hours and 15 minutes minus that 15-minute break. So Ms. Stone hit it right on the money. She said 2 hours. She came in with 2 hours. And Sherry M., thank you for the cups of coffee and the support through here. Really appreciate it. Thank you for making
We'll
this.
be recessed for 30 minutes.
Thank you. All right, so they're out for 30 minutes. Now let me put my scroller here so we know. Let's see, live court. So 30-minute break. So let's see. So 30 minutes, it's a 3:23, so 25 after, we'll say 4:50-ish, 4:55. That's, we'll go with 4:55. Okay. All right, let me end the poll. $536 votes. Let's see. We took a couple polls here. 536 votes. All right. So out of 1,091 votes, was Mrs. Ali an accomplice? 94% of you said yes, she is an accomplice. 5% of you said no, she is not an accomplice. And then because I only have certain fields, I only have 4 fields out of 536 votes. Which charge will Mr. Ali be found guilty of? Attempted deletion, 84%. 11% said assault. 2% said attempted kidnapping. And 1% said not guilty of all charges. I would have said assault and attempted murder for sure. Attempted kidnapping, I think that one's a stretch. But I think the attempted M and the assault for sure. But what did I say? Oh, did I screw that up? Yeah, no, you're right. Thank you. Thank you, Jeremiah. Yep, my bad. See, that's why I love you guys. You guys keep me in check. You guys keep me in check. 3:35, not 4:55. 3:55. Half hour. 3:55. What would I do without my chat? Double checking my work. I would be lost, wandering in the wilderness. Thank you, guys. Yes, 3:55. I just updated it. Thank you for that check. Appreciate it. All right, so let's go through what we heard. So Miss Stone talked for 2 hours and 15 minutes, basically, and there was like a 10-15-minute break, and she said it would be 2 hours. Now, doesn't she get a rebuttal? Like, is she going to come back with a rebuttal? I'm not sure. I would think she'd come back with a rebuttal. All right. So so count 3, she went through unlawful imprisonment for both. She talks about Mrs. Ali holding her. Both parents knew about restraint and how Fatima didn't consent. Yeah, Fatima definitely did not consent. Ihsan, okay, so then she talks about Ihsan only. You cannot strangle your child to restrain them. She says it seems really obvious, but apparently it needs to be spelled out. There were some moments there. She was generally okay. I thought could have been a little bit more spicy and, well, not spicy, but a little bit more engaging. So it did kind of drag a little bit. I know some of you liked it, some of you didn't. I'm kind of in the middle. I was like, yeah, it was okay. It was okay. I've seen better. But she has a lot of information. Miss Stone has a ton of information she had to lay out. And I thought she did. She was very thorough, for sure. She definitely was very thorough. All right, so let's see. You can't burn them. You can't throw them. You can't punch them with a closed fist. Then we get into assault in the first degree, intent to inflict great bodily harm or death. Then she talks about the physical discipline of a child. Is it reasonable and moderate? By the time he had her by the neck, he is furious. He is angry. Yeah, I think he just lost control. Well, maybe, I don't know. Maybe his intent was to kill her right off the bat. I don't know. Or once he saw Isaiah with his hand on his daughter, he's like, hey, wait a minute. She's not your property, basically, she's my daughter. You can't do that. Yeah, I don't know. So let's see. Lost my position there. Sorry, hold on. By the time he had her by, okay, yeah, parents don't correct or restrain children by strangling them. Yeah, okay, so objective, you have to reasonable and moderate force. You have to use objective, and you have to objectively use reasonable and moderate force. Then she talks about the assault in the second degree was the lesser included. We heard all about that from the jury instructions. Isaiah's not striking him, right? Isaiah's trying to disengage. Isaiah's like, he's got his hand on Fatima's back, and he's like, hey, Dad, step back. He didn't punch him. Isaiah got struck first. Isaiah knows that Mr. Ali is not going to just go over to Fatima and say, hey, come on, let's go home, let's talk about that. No, he grabs Fatima and throws her on the ground and starts choking her. So Isaiah has been around long enough that he knows, and he's concerned about her physically. Then we go to Zahraa. Mrs. Ali, her English isn't great, but she knows, we know that Zahraa can communicate, that she, we see instances where she's not the best, English speaker, but she can understand. They talk about that trespass letter, she had a protective order against Isaiah. She had no trespassing on all school property in Thurston County. And so not only did she go onto the property, but then she also went into the building. She went deeper into the office. So she just blew that violation order, trespassing letter, like out the window, just completely out the window. So she should definitely get hit with the trespassing. The family had, family had 1,000 stay 1,000 feet away from the family residence. So they had their own protective order out against her. So they knew. So both Haneen, who was the older daughter, and then Zahraa, they knew about the existence of the order because October 14th it was issued, and Officer Hang served it at their home, and we saw that testimony. We saw that body cam. They served it to them October 16th, and then here this happened on October 18th. So let's see lunch. All right. So what are you guys up to? I may take a quick break just to grab some food. Snowcat, I missed a little of closing. Did the state mention one-way ticket? They did not. They didn't mention anything about. No, that only came in through testimony. They didn't say anything about that in their closing. Maybe that will be rebuttal. Let me see. They didn't talk about that in their opening either. They didn't talk about that in their opening, and they didn't talk about that in their closing. So I have a feeling they're not allowed to talk about it. So not allowed to talk about it. Chantel, hello everyone. I'm just getting on. Did I miss anything besides states closing? Jury instructions. Thank you for joining us. First of all, Chantel, good to have you on board. Jury instructions and then the states closing. So that's all you've missed so far. Oh, Sharon, that's really nice. I'm going to continue to watch Jules Investigates in your playlist until court comes back. Cool. Yeah, definitely. There's some really good stuff in there for sure. Well, what did Birdie say? No, but defense did. Let me look that up. Let me just double check. If you remember that, I'm sure it's there. Let me see. Didn't talk to her parents about leaving. Parents were concerned. Talked to law enforcement throughout the day. But Fatima told people she had run away. I saw Ihsan first. Small patch of land. Daughter didn't want to travel with mom. So there you go. It was Zahraa. It was Mr. Leary. Good one. Good one, Birdie. Good one. Yeah. So, yep. And we'll do this during verdict watch. I'll pull up the openings and we'll watch Fatima and Isaiah because we'll have time to kill, right? So we can definitely rewatch that stuff. Yeah. So defense opening statement. It was short. It was definitely short, but he does say, Mr. Leary, Zahraa's defense, said, daughter didn't want to travel with mom. She never communicated this with her parents. That's all we know. So I don't know exactly what he said, but yeah. So good one, Bertie. Good one. Sally, do I think they'll start deliberations today? Very doubtful. If they do, it's going to be just to pick a four-person. It's going to be, because we still have to. So we're going to hear from the defense. They both said they were going to go 60 to 90 minutes each. They both said they were going to go 60 minutes each. That's another 2 hours. So they're coming back at, say, 4, just roughly 4. 2 hours is 6. Then they could get it for about a half an hour. They could get it for about a half an hour. Wybe, he opened the door to that. Kelly Graham, I love it here. Thank you. We love it that you're here with us. Appreciate that. Let's see. Bertie says, I remember him saying it, but I'm unsure if it was an argument to the judge thinking about it. It was in his opening. I just confirmed it was in his opening. So, hold on a sec. So in the affidavit, which was filed on October 21st, 2024, remember this happened on the 18th. This happened October 18th of 2024. So in the affidavit, it says, Isaiah's mother later called law enforcement. His mother stated that she was present during a CPS interview with Fatima, in which Fatima said that her father had recently been threatening her with an honor deletion for refusing an arranged marriage with an older man in another country. As of the drafting of this statement, further investigation remains ongoing. So they couldn't bring it in because she didn't say that in her statement. She didn't say that to law enforcement, I think, but so it was like kind of coming in through a third party. I think that's why they kept it out. I think that's part of why they kept it out. So it's almost like hearsay. Brian Walsh, we are not covering that trial, Melissa, so I can't give you any updates on that. Aussie Gardner, going to go make a cuppa. All right, go get your cuppa. Cuppa. I've got to get some food too. I'm going to go take a little break, just for a little bit. Sally, do you think mom's attorney will put the blame on dad? From what I remember from the opening, they were saying trust your eyes, trust the video, don't trust the witnesses. That was their main thing. And throughout the entire trial, they were pretty much saying, the witnesses are saying this, but Isaiah, you put your hands on him. You were beating him up. They were trying to deflect all over the place. So, trying to think in the opening, Mr. Leary was saying, didn't talk to parents about her leaving, so they were blaming Fatima. The parents were concerned. They called law enforcement. They talked to law enforcement throughout the entire day. Isaiah inserted himself between the parents and their daughters. Careful of what the witnesses say versus what you see. And her the condition that she had resolved the next day, and it wasn't life threatening. That was Mr. Leary, which is Zahra's defense. That's what they were saying. Now, Dad's attorney, Mr. Keating, was saying, I'm sorry, that was I was reading the wrong thing. Totally, I'm so sorry about that. That was Ihsan's opening. Then Zahra's opening was, look at what the witnesses say versus what you will see. So same thing. They both said the same thing. Daughter didn't want to travel with mom. She never communicated this with the parents. Can you do something else? Instead, she ran away at 4 a.m. They drove around Olympia looking for their daughter. Holds on to her daughter and not her neck. So he's saying, yeah. So they're basically blaming Fatima for not for not telling them that she didn't want to go with them. That was their opening basically. So that is Full of Life. That is Isaiah's father. His name is Victor, Mr. Barnes. Victor Barnes. Deborah, been in and out, so hoping for one of these great recaps. Thank you. I hope I gave you one enough that you understood it. And yes, it's only 12:30 in Washington, so they're coming back in maybe like 10 minutes or so. Snowcat, yeah, Victor seems like a good dad. 100% agree. Yeah, Mr. Barnes, Victor Barnes, he's a stand-up guy for sure. Is Fatima in the courtroom? Good question. I don't know. I'm not sure. Janet says the jury could get the jury could get the case by 4. They could, because it's say they come back in at 1. Both defense go for an hour, so that's 3 o'clock. There should be a rebuttal, right? So yeah, they could get it by 4, but they would only have a half an hour, and that's what Judge was saying. Judge was saying they would probably get it for about a half an hour. They would probably. That's what she was suggesting. Yeah, well, Sally, that was the defense. The defense was saying that they were saying that Fatima, she ran away. She didn't talk to the parents. They could have worked it out differently. I'm sorry. It's just you just don't choke your child. You just don't choke your child. Janet, I love your commentary. You explain everything so well. Thank you, Janet. Appreciate that. Thank you. Bice, no, defense has to go. Both sides have to go still. So we're still waiting for both sides, and both sides said they would be 60 minutes each. So we still have to get through defense, and then I'm hoping there's going to be a rebuttal. I don't know, maybe not. Rich Auntie says Miss Stone's closing was amazing. And yes, the black gentleman is Isaiah's father, as we spoke. Denise, yeah, just don't choke anyone, period. I know, right? Denise, I agree with you. Oh, did anyone watch Roar over the weekend? Roar? Sally Starr, you're welcome. Brad says motive is not an element of the crime. Vice, you're welcome. You are welcome too. Let's see what Chantal is saying. Psychosaurus Rex, yeah, they had a boatload of evidence. I love scientific evidence. He's 100% guilty. Well, we don't have kitty cam set up, but I can do you this. I can show you this, you guys. Let me just hold on. We got some kittens playing. Hey guys. Hi. So there's three of them with mom. Mom's back there. And there's three little ones right there. So that's Riker. And then that's Sid. And that's Houdini. So Riker was firstborn. That's why we call her Riker, after Will from Star Trek, of course. And then we've got little Sid, because she has a little mohawk. Even though Sid Vicious didn't have a mohawk, it's just the first thing that came to my mind. So we call her Sid. And then Houdini, little Harry Houdini, because she's always the escape artist. She's the first one that just would always escape and take off. I mean, not like take off, but we always had trouble finding her. And then, of course, mom's back there. Let me see. There's mom. Mom's sleeping comfortably. So there's one on the table too. Yes. Yeah. This is Super Ball. There's Super Ball. Yes. My Super Ball. Good girl. She's the big marshmallow. So there you go. Crazy old bat, that belongs to Super Ball. Super Ball is the one that you always see the tail. D3K2, you had a hamster named Houdini. Yeah, we call her Harry Houdini. Joyce, the defense attorneys, I believe, are court appointed. I do believe they have their own websites. If you look them up, they have their own websites, but I believe they are. Polly's doing fine. Yep. She's doing great. I'll show her again. Polly's she's back there. She's chilling. So the only one that you're not seeing is Roger Federer. He's floating around somewhere. I'm not quite sure where he is. He might be in the other room. So she's doing fine. And thank you for asking. Appreciate that. Yes, they are. Joe and Jedi Platypus. Oh, I hear something. Oh, he's coming out from under. Oh, hold on. He's coming out from under the printer. Let me go get him. Hold on a sec. They're all waking up. I can't get out of the way. All right, so there's Roger Federer. He's coming into the fray. Oh, it's on now. So there they are. Little kings. Yep. They're definitely waking up. It's time for them to wake up. Time for them to wake up and wreak havoc. I should probably go feed them, maybe. Yeah, we'll let them play. So Yes. Perfect life. Absolutely. Keith, they are. They turned 7 weeks last Thursday. So they are going to be 8 weeks. 8 weeks coming up. We've been doing live cat cams. We didn't do one this weekend because they're rarely in the in their room anymore. So I got to figure out. I guess I could go into the room and play with them. So maybe I'll do that. I want to do it this weekend because it's going to be there'll be 2 months. It'll be 2 months. So we set up a kitty cam and we've streamed about 6, I think, 5 or 6 now. We missed 2 weeks. Anyway, so that's on our channel if you want to go check that out. And I definitely got to shut these curtains because the sun is about to come in. Bear with me for a minute. All right. Yeah, I've been. Look at these two back here. They're just so cute. They're so distracting, right? They're just so distracting. Look at these two back here. The takedown. They're just beyond, just so cute. And their latest thing is like they hop around and they do the. They love to like just hop around on each other. We do have a playpen, Skybell. We actually have 3 playpens, and yeah, we have 3 playpens. And I may do that. We have one that's pretty big. I could put him in, yeah. Yeah, we thought about that. Like put him in a playpen and just let him flop around. So maybe we'll do that. I'll look into that that logistics. So yeah, we have 3. Pounce. Exactly, Pammy, sorry. Pounce. Totally. Birdie, thank you for sharing them with us. It is so good of you to have taken them in and loved them all. Yeah, thank you. Oh, thank you, Emma. Oh, wait a minute, let's see. Emma, thank you for your $2 donation. Appreciate that. LLH, how are you? Any estimation? They should be starting any minute, like literally any minute. Literally any minute. Yeah, it should be like within, because it went around 3:23 Eastern, and she said a half an hour. So yeah, it should be like any minute. I don't know if she's going to go. She should have just said till the top of the hour. She should have just said 4 o'clock, which would have been 1 o'clock her time. I don't know why she said a half an hour when it was like 23 after. Maybe it'll be at the top of the hour. I don't know. But in the meantime, we get to watch kitties. See, in the meantime, we get to watch kitties. Little kitties. All right, that's so, oh, we're going to get mom. And of course, Super Ball is here. This is Super Ball. Their little black tail. There's a little tail. Yeah, so good girl. She's enjoying her spot in the sun while these guys flop around. So cute. They get into everything. It's just amazing. They are just the cutest. All right, let me get back to here. We don't want to miss anything here. Aw, thank you. Thank you, Emma. Appreciate that. Giving big shout out filled with gratitude. Thank you. Appreciate that. Thank you for being a part. Does Super Ball like the kitties? No, she hisses at them. She hisses at them and she smacks them. That's what Super Bowl. Yeah, she's not the best with other cats. So, but she tolerates them. I guess if they don't get in her face, she's okay as long as they stay there and she has her little space. Hi, come up here. So here's little, this is Riker. This is firstborn. Little firstborn. Yeah. Hi. Hi. Yeah. That's good, kitty. Hi, hi, hi. Yeah, so this weekend I'll try and get something set up. Oh boy. I'll try and get something set up for Kitty Cam, but this is interesting. This is Super Ball's little spot. I definitely I gotta make sure that doesn't happen. We do not want them coming into her spot because that's her spot. All right, here, hold on. All right, dude, that's Super Ball's spot. Come here. Come here. Okay. There you go. I gotta make sure I don't roll over anybody because they're like right around my chair. Oh, they're like everywhere. They're everywhere. All right. Do we have a litter robot? We do not. Selena K. Let's see. You have a female ginger, which is rare. Yes. Her name is Miss Kitty. She is a runt and is still small. That is so sweet. Thank you, Selena, for your $4.99 gift. Yeah, both Rafa and Polly are small on the small side. Super Ball is just on the large side. So yeah, I'm hoping that they stay small. Doris, you have 15 cats. Wow. Buy them toy mice with catnip on it. We do. We have. It's funny. All the feral cats. Nobody likes catnip. Super Ball doesn't like it. Rafa and Polly, they're like whatever. They could care less about it. It's really funny how they don't care about the catnip. I have no idea, Camilla. Why are female gingers rare? I don't know. I have no idea. Every ginger I've known has been a male. So I know it happens, as Selena is saying, but I know that it is very, very rare. D3K2, I have a folded ear cat, and now ears look weird to you. So you have your cats were afraid of the litter robot. Emma, you have a cat's litter robot too. I've never even heard of that. Oh, you rescued her from a shelter. Wow. All right, hold on. I think they're climbing up my curtain right now. No, stop. They're chewing on cords. Hold on. Chewing on cords. All right. That is annoying. Come on. Chewing on cords is not a good thing. No chewing on cords. Yeah. Climbing curtains is one thing, but chewing on cords is a no-no. Have we seen Anubis lately? We have not. Birdie, yeah, we have not. Not for a couple days now. So, yeah, Amber Fox, not the cords. Anything but the cords. Emma, my cat only likes the homemade ones. Rescued a person 5 years ago. Sorry. SD Surf Girl, you're going to see Eddington tomorrow. What is Eddington? I'm not familiar with Eddington. Love how they line up. They are adorable. And they are spunky. Yes, green-eyed cat. And Byst, they are. Alexa, you owned a ginger in the 70s. Nice. Oh boy. Here. Oi. They're just beyond cute. All right, I've got to go deal with that. This is my life right now. Oh, it's a movie? Okay. That's Aaron my life right now. Oy. Little monkeys. Little monkeys. I think they're chewing on my sandal. Carol Ann, you have 3 cats? Nice. Yeah, there are no cat owners, only cat slaves. I agree, Kaylee. I agree. And they choose us, right? Don't they choose us? I think that's, I fully believe that statement. That cats choose you. You don't choose the cats. Cats choose you. Dogs rule. Northwest. We know we're Northwest lands. Dogs rule. Cats rule. I think you said that last week. Oh, Carol, you're gonna get. You can't. YouTube has coon as a negative name, or that's a negative connotation. So I'll read your comment. 2 are Maine Coons. Other one is short hair. Sorry, Carol. It's YouTube. It's one of those words that coon is, it has historical negative connotations. So let's see. Janet also got. Let's see. Why did you? Yeah, you guys can't say Maine Coon. You can't say coon. Sorry, guys. Sorry. Some of it's going through. Some of it's not. I don't understand. Anyway, generally COON, coon, you can't say because it has historical negative connotations. Katie Cat. Hey everyone, sneaking in here late. I heard the prosecution's closing were a bit of a snorefest. I'll watch them later anyway. Yeah, it wasn't, I don't know. Coon, COON. The word coon, it has negative racial connotations. So it happens. It's happened to us before. Just, yeah. I guess just say Maine, just misspell it, say C with some exclamation points in it or something. It's YouTube. It is what it is. So sorry about that. See, some people, yeah, there you go. Maybe with a K. Yeah, Maine Coon, spell it with a K. We'll know what you mean. We'll know what you mean. A very big cat. I know, Carol. It's YouTube. It's just YouTube. That's what they do. We don't make the rules. We don't make the words. We have a bot that captures words and that it's on their list, and that's on their list. Yeah, you could do that. Maine, put a space in between it. You just have to be more, I guess, clever than YouTube. You have to out-clever YouTube. They have a list of words that you can't say, and we have a bot that does that, but we don't have any control over the words that they. That's just the way it is. So. Ragdolls, is that what you have, D3? You start sprinting everywhere, that's what you have? Oh, Selena, thank you for that. You have 2 shelter cats, 2 shelter dogs. They have learned to get along. Absolutely. I was just talking to, thank you for your donation. Really appreciate that, Selena. I was talking to, we were talking to Aussie. Why can't I like that? Oh, there we go. Yeah, maybe Cocoon. You could try that. Yeah. We were talking to Aussie Gardner last night, and it's like, we had 2 Jack Russells, and then the vet says, oh, you have a cat. The Jack Russells are going to be at war. No. No, that our cat loved the Jack Russells, and the Jack Russells loved the cat. So we were talking to Aussie last night, and it's like, I think it's the owner, right? It's the pet owner that sets the tone of the house. You know, if you're calm and your pets are calm, you know, your pets will get along. You know, I think that's really the key. You know, I think all animals, you know, could get along, probably should get along, but it boils down to the pet owners. You know, got some activity back there, little munchkins fighting back there. They're doing the death kick on each other. SD, you have a rag doll. I think rescue animals are the most amazing of all. I agree. Oh, you have a Scottish fold. Okay. D3K2 has a Scottish fold. I'm not familiar with that. Rag dolls I am familiar with. SD Surf Girl. Is that San Diego? Is that SD for San Diego? Just wondering. Totally 100% we had to work with ours, right? Irene, totally boils down to the owners. 100%. Yep. Are chickens friendly? Like, do they have personalities? They do. And Aussie, I'll let you handle that one. Are you already talking about that? Am I missing your chat if you're already talking about it? Is Aussie talking about it? Emma, your Persian wakes up at 10 p.m. and sounds like thunder romping around. Nice. Jerry K, her name is Fluffy. Any guesses why? Yeah, Polly has a fluffy tail, a floofy tail. We call her Floof, or Floofy. Ms. Holmes, your son and daughter-in-law have a beautiful rag doll. Nice. Born Free, you had a rag doll for over 17 years. Very cool. Oh, looks like they're back.
Please be seated. Members of the jury, if you would now please give your full attention to Mr. Kading as he makes closing argument on behalf of defendant Mr. Ali.
Thank you, Your Honor. Good afternoon, everyone. All right. Where are we? We're at the end, nearing the end. What I would like to tell you is that this is my opportunity to address you. When I'm done, Mr. Leary will address you, and then finally the prosecutor will get what's called a rebuttal. All right, so they'll get an opportunity to take all of the brilliance that I'm going to put in front of you.
I'm sorry,
and tear it apart.
Mr. Kading, you're
Yes.
going to need to speak up.
I'm sorry.
Thank you.
Do I need to be nearer a microphone?
Probably, I would think so.
All right. Sorry. Okay. So, this is my opportunity to tell you that I see this case, obviously, different from what the prosecutor saw. What I'm going to tell you is this case boils down to 53 seconds for Mr. Ali. 53 seconds from when we start the bus video until Mr. Ali is laying prostrate on the ground unconscious. Okay? That's the amount of time we're talking about. What I want to know is, how did we get to those 53 seconds? And what do we know that's been presented here as evidence? I'm going to tell you right away, the first thing is, there's two distinct groups in this case. Pretty obvious, right? We have the Ali family, and then we have Fatima's contacts outside the family. All right? Those are the two groups. They don't meet very often. All right? We know, for example, Isaiah was dating Fatima for approximately 10 months, per his testimony. We know from Mr. Barnes and we know from Noah that they were in love. That's what we heard. What we didn't hear, though, was that Mr. Ali knew about that prior to at least September 16th. He did not know that Isaiah was his daughter's boyfriend. He did not know she was in a relationship. He had no way of knowing because she hid that from him. We heard from Isaiah, for example. They had clandestine meetings in the park. They didn't interact with each other's families at all. We know that Isaiah's contact with the family consisted of talking to daughter Haneen on 1 or 2 occasions, and that was it. We do know that Isaiah and his family was aware that Fatima was not to be dating. But they disregarded that, chose to anyway. In order to do that, they had to keep everything secret. So they're living in a secret world. What else do we know about that? We know that all of the information that came to Isaiah was through Fatima. He didn't have contact with anyone else to find anything out. He didn't have a way to corroborate what she was telling him. She was just taking her at her word as to what was happening, right? The problem is, as we found, Fatima is what we would like to call an unreliable narrator, right? She tells stories. She doesn't always tell the truth, but she's controlling the narrative on the non-Ali family side, which includes not only Isaiah, but his friends and the school. We know that Fatima has contact with them. We know that the family contact with the school is pretty limited. As a matter of fact, after September 16th, family contact with the school was 0 until October 18th. Now, we could go into a lot of reasons as to why there was no contact, but it seems pretty clear that when Assistant Principal Walter Meyer decided that Zahraa Ali was no longer allowed at the school, Zahraa Ali took steps to put her daughter in a different school. To North Thurston High School was her choice. Eventually, she got set up in online school. Okay? So, where do we get to on October 18th? We have a situation where Mr. Ali is pretty much in the dark. We know from Mr. Barnes that Mr. Ali talked to him on the telephone, apparently, on the 16th of September. Mr. Barnes said he called him, talked to him. We know that Mr. Barnes said that Mr. Ali came to his house the weekend before this incident. And that is what prompted him, at that point, to go get the restraining order on the 14th, which was Monday. Okay? So that is the contact that they've had as families. There's been no talk about the kids. There's been no talk about this relationship. There's been none of that. Okay? And Mr. Ali knows nothing about Isaiah. He's never met him. Never seen him. Okay? So the scene that we have on the 18th is a situation where Fatima has decided that she's going to run away from home. Okay? Why does she want to run away? because she doesn't want to travel with her mother, her sister, and her 2 little brothers to Iraq. Now, she's been to Iraq before. She said it was okay, but she said there were times that she didn't feel safe. She goes to school after running away on the 18th and talks to her counselor. Let's back up. We know that she was planning to run away because we know on the 17th she said she set her alarm for 4 a.m. so that she could get up and run away the next morning. She gets up, she gathers a few items, she runs out of the house before anyone else is awake. We know that she's hiding out. She goes to between Walmart and Safeway, she goes to the bus stop, she's going around hiding out so that her parents won't find her. She says at some point she saw her parents driving around looking for her in the morning. We know the parents called the police that day, talked to Dr. Hang. Early morning, he said about 8:30. He talks to them. They say she's missing. We don't know where she is. Now, at that point, he doesn't fill out a runaway report. But what does he do? He goes and checks a couple of things. He goes and checks around Safeway. He goes and checks at Isaiah's house. And apparently, according to him, has Isaiah's mom call the school, I guess to see if Isaiah is there. I don't know. I don't know that they would tell her if Fatima was there. But we know the officer Hang did not follow up with the school himself. Okay? So, we have Fatima going to school. I think it's telling what she does first. She goes to a first period class so she can talk to Isaiah. Isaiah, she says to him that she's running away, tells him the story. He's like, okay. She goes and talks to a counselor. She talks to her former mental health counselor, Liz Robinson, and she's talking about, oh, we need to help you because going to Iraq, you don't feel safe. Now, it's an interesting scenario with Mrs. Robinson because she's able to call law enforcement or CPS if she thinks someone's in immediate danger. But she doesn't do that in this case. And she chooses not to call the Alis at all. She said, well, I have confidentiality. Fatima didn't want me to call. Okay. So the scenario now is Fatima's run away. Her parents have no idea where she is. They've called the police. Fatima's at the school. Nobody from the school calls the Alis to say, your daughter's safe. I mean, I don't suppose they're required to say, we're calling from the school, your daughter's safe. They could just call and say, your daughter's safe. Don't worry about her. They could do it anonymously. Hey, we have your daughter. We're talking to her. But they don't. They choose not to do that. They leave the Ali family in the dark all day. So, what do the Alis do during the day? They talk to the police. They're looking around for her. Apparently, according to Walter Meyer, the other daughter, Nora, who we didn't hear much about, was seen at Timberline that day. Now, we don't know why she was there. She wasn't a student at the time, but we can assume maybe she was looking for her sister. Just putting it out there because she was on the videotape in the school. All right? Now, what's happening during the day? Liz Robinson is coordinating to help Fatima get out of her own house. She's arranging shelter. Now, remember, there's no imminent danger. She's just arranging shelter because Fatima has told her, I don't want to go to Iraq, I don't feel safe. She said it was okay, but I don't feel safe all the time. Now, that's an issue right there that's a parental decision on where your kids go. If you're going to Iraq and you want to take your child with you, that's your choice. It's not somebody else's choice. It's your choice as a parent. So, what Liz has done, Mrs. Robinson, what she's done is now she's inserted herself into a family decision, right? She's telling Fatima, you don't have to go home. You can go to a shelter. I'll help you. And they get it done. Again, nobody's talking to the Ali family. Nobody's telling them what the plan is. They have no idea. So, what else happens that day? Well, we know that Isaiah talks to her again, fourth period. We know that after school, Isaiah meets her at the front of the school. She waits for him, and he comes out, and they go to the bus together. Now, at this point, they walk past Mr. Ali's truck. if I can get that up there. This is exhibit, oops, 106, page 3. We can see there, right here in the sidewalk, Mr. Ali's truck. Oh, nice. Mr. Ali's truck is right here. So clearly, they see Mr. Ali. Mr. Ali can see them. Now, interestingly, the time on this photo, if you look down in the corner, it's not the time of day. It's just the time of the extent of the video. 9 minutes, 29 seconds. Okay. If we look then at page 5 of the same exhibit, we're going to note now that Mr. Ali has moved his truck from this spot and he's driving over towards the bus stop. Okay? Now, why is this important? It's important because there was a 2-minute delay there. Okay? Mr. Ali did not immediately jump out of his truck and go grab his daughter. We don't know what he did at that point. We do know that a couple of minutes later, his wife and daughter show up at the parking lot. Okay? So, Mr. Ali is not going, obviously, to the parking lot to grab his daughter because he sees her walk by and he doesn't grab her. She goes off to the bus stop where she's talking to other students. And we know Isaiah's talking to other students. He talked to Noah. He's talked to, I forgot his name, but he talks to Noah. We remember Noah. They're in love, man. Right? That's Noah. He talks to him and says, be prepared. Be ready. Isaiah himself says, I was ready for anything. Okay? So this is occurring while Mr. Ali is in his truck. He has no idea what's going on. He's never even seen Isaiah before this point. Right? In his life. He's never seen him. Mr. Ali drives over to the bus stop to go talk to his daughter. Okay? He talks to his daughter, as we heard from several witnesses in a calm voice. You got to come home. She says, no, I don't want to come home. He goes, come home with me. This goes on, back and forth. She refuses to go. Okay? She's his 17-year-old daughter. She's a reported runaway. He wants her to go home. She doesn't want to go. That's where we are. He reaches out and touches her, grabs her shoulder. That's what we heard. Grabbing her shoulder in this situation is not an assault. Because, as we saw in one of the instructions, you have the right to control your child. Right? Parental discipline. You're coming with me. Okay? At that point, Isaiah interjects himself into what's happening. Okay? What does he do? He says, well, I tried to push him away. Let's take a look and see what we can find here on the video. This is Exhibit 34, the bus video. If we can turn that on. And this is the frame from 2:13:14 seconds, frame number 6, and they're all individually framed. Now, I just noticed, ironically, if you look right here on the left side where the arrow is on the right side photo, there is Haneen and her mother's car that's just now getting to the school. All right. But let's take a closer look at the view of what's happening at the bus stop as the bus comes into view here.
And Mr. Kading, can you indicate which camera view
Oh yeah,
this
I'm
is?
sorry. This is the road view of Exhibit 34 at 2 minutes, 13 seconds, and 14. All right, hang on just a minute here. Let's back up just a little bit. And I've stopped it at 2:13:17. All right, get caught up here on my timeline. Okay, 2:13:17:5 is where we're going to go. And that is going to be 5 frames from here. Now, if we look in this frame right here, we can see Mr. Ali. He's right there. Okay. okay? He's standing there. Some of the other people are standing there watching him. There's been no physical contact yet, but you can see something going up in his eye, in his face there. And what you're going to see is you're going to see that it's Isaiah's hand pushing him away. All right, so let's watch this slowly in quarter speed from 2:13:17 to 2:13:18. You can now see the hand right there in front of his face. Okay. Now you can see he's walking backwards, and he's still got Isaiah trying to hang on to Fatima. And if we stop it right there, this is just after the punch to Isaiah. Now, if we add on to this view the front door photo, right next to it, you can see, here they are on the right side of the photo. There's a punch here. Now, what you're going to see is you're going to see Isaiah take about 2 steps, and he's going to turn around and he's going to point at Mr. Ali, and he's going to yell to some friends. Okay? And you can see that here in the video. Let's play that. Quarter speed, we'll play it. If we watch that video on the right, you can see Isaiah doesn't hit the ground. He doesn't go down. He just stands up and he points right there. And then at that point, he starts running towards Mr. Ali. Okay? Now we're back on the left side. You can see him taking...
Can you indicate the time that you paused?
Oh, I'm sorry. This is 2:13:25. All right? So let's close this one out. And then we're at 2:13:25, and you can see up here on the right underneath this tree is Caleb, who's going to be coming in here in a second. Now, on the left, we got Mr. Ali, and we've got Fatima, who are kind of been, we can back it up just a little bit. Let me back it up just a hair to 2:13:22, and we play that, and we see Mr. Ali go to get his daughter. Now remember, his truck is right here now at this point, and he's trying to get her in the truck. At this point, she's still squirming around, and she's standing up, and she's going to the left. Now, right here, he gets attacked, right? We see Isaiah come running in from across the way. And what did Isaiah tell us? He says, well, I was mad at him for hitting me, okay? He's not at that point going in to protect Fatima from anything. He's mad, and he attacks Mr. Ali. Now, we have another photo. This is exhibit 501, if I could just put this on for a moment. Remember 501. This is the photo of the frame where Isaiah has his arm up in the air and he's taking a swing at Mr. Ali, and Fatima's there. Now, what's interesting about this is that he can't really see Fatima from this point. I mean, he's coming in at the same angle as the camera. He says that he's trying to protect her, but really what he's doing is he's taking a swing at Mr. Ali because he's mad at him. Okay, that's what he said. And what he does after this is he pushes him into that tree. Thank you, Madam Clerk. If we go back to the video. Now I'm going to back up the video here just a hair so we can see a little bit better what's going on. And we're at 2:13:27. Let's back it up just a little bit to 2:13:25. Okay, and so here's Mr. Ali. He's wrestling with Fatima, but he doesn't have arms around her neck. Okay, that's what we kept hearing people say. He's got his arms around her in a reverse chokehold. No, he doesn't. We can see he's got his elbow up on this side and his hand over on this side. She's squirming around over here, and clearly she's trying to get away from him. Okay? So here comes Isaiah. Boom, hits him. Caleb comes in.
Can you indicate what time you stopped?
Oh, I'm sorry. This is 2:13:26. Caleb comes in from the right side. Now, he's not pulling anyone away. You can see he's pretty clearly pushing Mr. Ali, or excuse me, he's pushing Isaiah in the back. Mr. Ali here next to the tree, and these are the legs of Fatima over here. Okay? So, There was no falling to the ground. This was clearly being tackled to the ground by at least these two people. And I think we're going to see Zayla. All right? You can see him hit the tree, and boom. At this point, everybody's on the ground. And right there, excuse me, I'm going to pause it again, 2:13:29. So we haven't gone very far in the video here. The first thing we see is Isaiah kicking Mr. Ali in the head, right? He's on the ground kicking Mr. Ali in the head. Start it up again. Now, right there, between 2:13:29 and 2:13:30, frame 8, you can see Mr. Ali on the ground, underneath Caleb's feet here. And if you watch him, after he gets kicked in the head, right there, he kind of curls up at that point. All right? And then additional hitting and kicking is happening very quickly. We're 3 seconds in here. He's getting hit in the head, he's getting kicked in the head, and he's hanging on to Fatima. Now, remember this scenario. We're at the bus stop. Somebody we don't know comes up to us, gets between us and our daughter. This is Isaiah at the time. And he starts putting his hands up in my throat, my neck area, because I'm trying to take my daughter home. Okay? Mr. Ali takes one punch at him to get him away. Doesn't even knock him to the ground. He just kind of gets him off. Then he's heading over to still get his daughter into the car. He's the father. He's the concerned father who hasn't heard anything about where she's been all day, other than here she sits at the bus stop, right? He does not know these people. These people come at him and attack him at that point. He's got his daughter with him. He's trying to control his daughter. She's trying to get away. And so what does he do? He hangs on. Okay? He's hanging on to his daughter. She's in front of him on the ground, and he's got it. He's kind of curled around her, and he's hanging on. Now, the government would have you think that at that point, he's strangling her, and he's intending to kill her. When in fact, what we see is a man laying on the ground who just got kicked in the head, holding on to his daughter. Now, why is that important? Well, because if you remember when we were talking to Dr. Gilbert, I asked her a couple of things about blows to the head, right? I said, well, what about hitting the tree with your head? She said, well, Fatima didn't have anything on her head. And I said, well, what about if you kick somebody in the head? Oh, yeah, that can cause problems. That can cause cerebral edema or concussion. What happens when you get those? Well, your body functions, but you can't control it, right? That's where we're at. We're at a place where a guy is on the ground, he's being attacked, he's being punched, he's being kicked in the head while he has his daughter. Apparently, while that's happening in these few seconds, he's forming some sort of an intent to strangle her. There's no evidence that was ever put forth that he was intending to strangle her. What we have here is we have a melee, a mob, right? We have chaos going on. And at this point, what happens is they start yelling and screaming at him to let her go. That's what they're screaming, right? I'm going to start the video here at 2:13:34. Let's play it at full speed for the next few seconds. Turn on some audio as well. All right? So let's watch what happens. Oh, I don't know where the audio is. Stopping it now, 2:13:38, frame 9. You can see Isaiah is right there pounding on Mr. Ali's head. Up and down, many times. Now, we haven't got to the point yet where Caleb drags Mr. Ali. He doesn't grab his arm and try and pull his arm free. What he does is he grabs him by the bottom of the coat and yanks it up. You can see Mr. Ali's back come up. He drags him away from the tree. That's where he's going with that. Doesn't drag him very far, but he drags him away from the tree. Let's watch that. I'm going to start at 2:13:38. Right there. Now, he's not grabbing his arms. He's grabbing at his coat, he's grabbing on his back, and he's yanking him across the ground. Meanwhile, Fatima, who allegedly they're trying to protect, is underneath Mr. Ali. Mr. Ali is on his stomach right there. He is on his stomach being dragged by somebody he doesn't know, punched by somebody he doesn't know, across the ground with his daughter with him, and he's hanging on. He doesn't want anyone to snatch his daughter. He wants to hang on to his daughter, right? So, watch it again. Keep going from there. Kicking, punching, hitting. Now, at that point, you could see Fatima, and there comes the bus driver, Mr. Denicola. All right? I'm going to stop it now. 2:13:54. We're 40 seconds into this video. That's where we are. Mr. Denicola is there. Now, what he said was that he went there and he stopped the assault. Contrary to what Mr. Wagner said. Mr. Wagner said he stopped the assault. And then finally, of course, Isaiah says, no, it was me. I stopped the assault because I knocked him out. That's what he said. Okay? So one of the three of them knocked him out. Now, I don't know Josh Wagner, but I do know this. He ordered the tape on this case, he said, from a public records request 6 months ago. We can assume he watched it. He said he got there before the bus driver. He's not there yet because he didn't get there before the bus driver. Mr. Denicola was there. Bending down. Going to start again from 2:13:54. You can see in the background there, Isaiah is still hitting. Now, here we are at 2:14. Okay, this is 2:14:00. This is when Mr. Wagner appears from the left wearing the hunter's cap, and right here you can see Mrs. Ali. Okay, bent over Fatima and her father right here is the bus driver who said he was loosening any remaining grip from around Fatima's throat. All right. Now, there was a point, and we've seen it, where Fatima goes limp. Okay. What I want to tell you is, you can see at this point, I will give you the exact frame, 2:14:02.8, she starts moving her feet. Okay? So we can assume at that point that whatever has been compressing her throat has been removed. Now, let's assume for a minute that it is her dad's arm that's compressing her throat. Seems reasonable, right? We can all agree on that. Whether or not there's a crime, though, requires more than that, okay? There has to be an intent to assault, okay? An intent is not just, oh, well, there's obviously intent because it happened. No. Intent requires purpose, right? You have to be acting to make something happen. I'm going to give you an example, all right? This is one of my favorite intent examples. You're in a basketball game. 2 seconds left in the game, you're on defense, right? You're down at the other team's offensive end, and the guy's dribbling, you steal the ball from him. You win the game, right? Enjoy a celebration with a second left, you throw the ball up in the air, right? It goes through the basket, you lose the game. Because you threw it up before the clock went, right? You didn't intend it to happen. It certainly happened. There certainly were consequences of it happening because the ball went through the hoop. That doesn't mean you intended for the ball to go through the hoop just because you threw it in the air, right? You didn't have the purpose. Cost you the game. You lost. No intent. Bad consequence. That happens. Accidents happen. Situations happen where you're attacked by a mob and you don't know exactly what's going on. You've got people yelling, people kicking, people hitting you. You're laying there. You don't know what's happening. You're hanging on. You've been kicked in the head. You could have edema, cerebral edema. You could have a concussion. You could have any of these things. Then you say, well, where's the evidence of that? The evidence of that is that when asked, Mr. Ali, 40 minutes after this incident, do you want to see a doctor? He says no. That's the medical that we have on Mr. Ali. There's no way to know what happened at that time because no medical exam was done. They listened to a guy who just clearly been beat about the head and neck area, right? He'd been beat severely. They asked him for his opinion on whether he needs to go to the doctor. Doesn't make any sense. He's been knocked out. According to Isaiah, he punched him enough times, he broke his hand on his head, and he knocked him out. That's where we are, okay? Now let me play the video for just a couple more seconds here. We're at 2:14:02. Let's play it. Until there. You can see at that point, it's kind of hard. I'm sorry, Your Honor. 2:14:08, frame 6. Again, you guys will have all of this in the room. You can take a look at it. If you look right here, you can see that Fatima is laying there next to her father. And at this point, this is the hat right here of Mr. Wagner. And he then sits on Mr. Ali for the remainder. Mr. Ali no longer moves from that point for the next several minutes. Okay? And it's not until Officer Hang comes and arrests him. So that's the end of that video. 2:14:08. That's the 53 seconds that we're talking about. That's the amount of time for all of this to happen where Mr. Ali allegedly formed the intent to kill his daughter. That's what they're thinking that he was doing. A man who called the police when his daughter was missing. Not just once, but at least twice. A man who spent the day looking for his daughter. He finds her. He wants to take her home. He has no idea what's going on, except that she ran away that morning. No one has had the courtesy to call him and tell him what's happening. So what does he do? He goes, he tries to take her home. He gets attacked by a mob. He's beat about the head and neck area. And allegedly, he has at that point informed intent to either A, kill his daughter, which obviously didn't want to do, or B, seriously maim her. Assault 1. No. The question is, did he strangle her with an intent? Did he intend it? Was it intended at all when he's there? Or is it just circumstantial, right? Just because I'm on the ground, I've been tackled, I've been dragged, I've been kicked, I've been punched, I'm hanging on to my daughter. I don't know who these people are trying to take her, but I sure don't want to let her go. Something a father would do. Something a father would want to do, hang on to his child. Now, is it unfortunate that her neck was compressed? Yes, it was. But that is not a crime if you don't intend it. Okay? Now, it probably would have been better in this case if all the witnesses hadn't watched this video before coming to testify, because it's possible some of their testimony could have been contaminated by what they saw, which is different than what they remembered. But it all was the same pretty much, except they still made mistakes, right? They still made mistakes because they didn't want to know what they had done. Now, I want to just talk a little bit more about the witnesses that we heard from. We heard from Dr. Gilbert. She's the one who testified. She said the body's an amazing thing. What she also said, if you're knocked unconscious, it says the body's functioning, but the ability to control it is not there. Okay? If you're hit in the head and you're concussed, you lose your abilities to use your brain. If you don't have the ability to use your brain, you can't form the intent necessary to commit the crimes that the government is alleging. Right? They said he did not go to school with a plan to kill his daughter. He did not develop a plan to kill his daughter between when he got out of his truck and when he was tackled to the ground. What he did was develop the intent to hang on, to protect his daughter. They showed nothing else. They showed no evidence of anything. They didn't have him saying, I'm going to do this, I'm going to do that. They had no evidence of anyone hearing him making any threats. They had no evidence of any of that because there wasn't any. No intent. What was in his mind? Did they prove it to you beyond a reasonable doubt? Get into jury instructions beyond a reasonable doubt. Something A doubt for which there is a reason. Okay? As to any single element of a crime. And in this case, intent. Is there a doubt as to his intent? Yes, there is. How do we know? Because they didn't provide us any evidence. They provided us physical activities that were going on. A mob beating a man getting punched and kicked in the head, a man getting dragged across the ground, a man hanging onto his daughter. And from that, they're trying to have you think, well, intent to kill. If not intent to kill, intent to maim. If not intent to maim, intent to strangle. None of that was proven. None of that was proven in this case. No intent. And let's talk about parental rights, right? You have the right, when your daughter is gone, run away, to take her home. That is your parental right. Okay? Grabbing her by the shoulder, taking her home is not against the law. Okay? What happened here, though? Isaiah got himself involved in this. He put himself in the situation and made it physical. He grabbed Mr. Ali, he stuck his hand up in his face, he pulled on Fatima, and he was wrestling with Mr. Ali. Again, Mr. Ali doesn't even know him. Doesn't know who this guy is, doesn't know what his intent is with his daughter, right? Mr. Ali does what? He punches him one time to get him away. He doesn't knock him to the ground, he doesn't knock him out. He hits him. Isaiah literally takes one step back before he turns, points, and yells. Starts running back towards Mr. Ali. He doesn't run to protect Fatima. He runs to get Mr. Ali, the man who just hit him. He's angry. Okay? So the question is, was the punch that Mr. Ali threw reasonable? If it's not reasonable, it's not self-defense. But what does he have? He has a guy he doesn't know, grabbing at his throat area, pushing him around, turns around, takes one swing at him, turns around and walks away. Right? He doesn't go beat him up. He doesn't pound him into the ground. He doesn't kick him in the head. He punches him once, goes back to what he's doing, which is trying to get his runaway daughter home. Okay? Trying to get his runaway daughter home, not a crime. All right? Striking someone when they're interfering with you, getting your daughter, by grabbing at you, you can defend yourself as long as it's reasonable. Right? He didn't pull a gun out and shoot Isaiah. That would be unreasonable, right? He got him, he hit him once, he turned around, he went away. That's self-defense. All right? Now, what about some of the other issues that they're bringing in? Again, they become kind of irrelevant. There's no intent to kill, there's no intent to do serious bodily injury. The only injury that they had in this case that lasted was this pneumomediastinum. What did we hear about pneumomediastinum? We heard that usually it just goes away, right? It's air in your cavity. It went away in this case. By 8:30 the next morning, it was not getting worse. She had been monitored, no problems noted. It's over. That is not a serious bodily injury, a great bodily injury. It's none of those things, okay? What you're going to be asked to do is look at these different things, and you're going to have to say, well, did he intend this? Well, I'm saying he didn't intend anything. But if you read it, first of all, for assault 1, did he intend great bodily injury? Okay? That's permanent injury. Did you plan on permanently injuring somebody? Did you plan on permanently disfiguring them? Did you cut a finger off, or cut their ear off, or cut their nose off, or something? No. Did you cause a permanent functional issue with one of their organs? Did you pop an eye out? Did you do any of those things? No, you didn't. That's great bodily injury. You're going to notice in your instructions, which are a freight train, I know, assault 2 is different. Assault 2 is substantial bodily injury. That's already significantly less than great bodily injury. That's substantial bodily injury. The definition for substantial bodily injury: was it something that happened that is somewhat temporary, right? I mean, you could say, I guess, if you intended to strangle someone and cut off their air and blood, you could say, well, that's substantial bodily injury because it temporarily cut off their blood flow, right? It's not great bodily injury because it didn't cause any permanent damage. It didn't have anything that was going to last forever, all right? So part of the issue with the jury instructions is they're quite long. They're quite lengthy for all the different crimes, okay? But the definitions are all there. And so what you have to do is you have to take a look at them and say, okay, of the elements, what did they prove? Did they prove intent on all the assaults and the murder, attempted murder? Did they prove intent? What evidence did we have that we can now find factually that they have proved that beyond a reasonable doubt? They've proved it beyond the point where we have no reason to doubt their evidence. Not a single reason. Okay? It doesn't have to be a series of reasons, and it doesn't have to be a series of elements. It has to be one reason for an element not being proved. One reason to give you a doubt. Now, the prosecutor also talked about abiding belief. I like abiding belief as well. Abiding belief doesn't mean it's not proof beyond a reasonable doubt. It means that you are so convinced that that will never change. Okay? You are not going to wake up tomorrow and say, oh, you know what, I just thought they didn't prove this, right? Because they failed to do this. An abiding belief means you're going to remember that for the rest of your life. It's never going to change. Okay? You're not going to reconsider in a month. You're not going to reconsider in a year. You're not going to reconsider and say, gosh, you know, maybe they didn't prove that. That's a hard standard. That's beyond a reasonable doubt. If you have a reason, if you have a doubt, that's all you need. They have the burden. They've undertaken the burden. And in this case, they did not meet the burden. All right? They didn't meet the burden for attempted murder because they didn't show any intent to kill. They didn't meet the burden for assault 1 because they didn't show the intent necessary to get to assault 1. Okay? They showed a couple of minor injuries. All of those injuries could be associated with an accidental situation, right? I have my arms around you, a guy's dragging me on top of you, I could be strangling you at that point. The other thing is to remember about strangulation is it doesn't take much, right? It doesn't take much to strangle somebody. 4 pounds of pressure is what I heard from Dr. Gilbert. If you stop some sort of a vein, and 11 pounds of pressure if it's an artery, okay? Interestingly, she threw in 6 pounds of pressure for a pistol trigger, right? And much more than that for even a soft handshake. Much more than 11 pounds. A firm handshake, more than that, but not very much. Think about a handshake. That's how much pressure is more than 11 pounds. It could happen in a situation where you're hanging on to somebody, your hands get up around their neck, and you get dragged across the ground. At that point, after being kicked in the head, you may not realize what you're doing, right? You may not have the ability to know what your body's doing. People are screaming at you. People are kicking you. Up until the very last minute, Isaiah was punching him in the head. Up until the very last minute when Zahraa comes in and pushes Isaiah off. She pushes Isaiah. Isaiah says at that point he's knocked him out. Mr. Ali's laying on the ground. He's not moving. Everything's over at that point. Okay? He's that close to getting knocked out when all of this is happening. And we don't know at what point he lost his ability to reason and function. Now, I've already touched on a couple of these things. One of the things that you're to talk about in Instruction 1, I just wanted to mention a couple of things. I'm not going to go through all of them. Anyone that has personal interest in the outcome can have bias, okay? Personal interest in this case, essentially everyone involved in this case has a personal interest, right? They all say, well, that's what I saw. Well, did you? Because a lot of what I heard from the testimony was different and what we saw in the video, okay? Proof beyond a reasonable doubt, we just talked about briefly. Instruction 12 is the intent instruction. Prove to you beyond a reasonable doubt the objective or purpose of the defendant's actions was to accomplish a result that constitutes a crime. Again, objective or purpose, okay? You have to set out to do something. I can easily imagine a situation where you intend to strangle somebody. They're standing over there, you're mad at them, you go and you grab them around the throat and you strangle them, right? That would be clear intent. There's no mistakes, no accident, no way that you couldn't mean to do what you're doing. That demonstrates intent. We don't have that in this case. I think that the prosecutor's already touched on some of the other ones, like recklessly. Again, the degrees of injuries are different. The intent element, mens rea, the mind's thought process is different between assault 1 and assault 2. Okay? So make sure that you read the instructions carefully. And instruction 25, I made a note. And if you read instruction 25, let me just take a quick look and see what I did here. It says, this is about recklessness, right? A person is reckless or acts recklessly when he or she knows of and disregards substantial risk that a wrongful act may occur, and this disregard is a gross deviation from conduct that a reasonable person would exercise in the same situation. Okay? So, was he reckless? Was Mr. Ali reckless? Well, let's talk about the situation. He's on the ground, getting beat and kicked by people he doesn't know. Okay? And at that point, he hangs on to his daughter. Is that reckless? If you were in the same situation, a reasonable person, and that was going on, what would you be expected to do? Would you be expected to do something different? If you were going to act the same, you're not being reckless, right? Reckless, deviating from what they're doing in the same situation. Gross deviation, okay? Now, this all comes down to what a parent would do in a similar situation. Your daughter's run away. You don't know what's happening. You see her at the bus stop. You go to talk to her. She tells you she doesn't want to go. She's your child. You have the parental duty to parent, right? That's your duty as a parent. You say, we're coming home. She says, no, I don't want to go. A struggle ensues. And here we are. That's what this case is all about. There's no nefarious intents. There's no intents to hurt anybody badly. There's no intents to kill anybody. There's an intent to take your daughter home. 17-year-old daughter who's run away. We know she's run away before, because we know from Mr. Barnes and Corporal Stanford that that's why they were at the house looking for him the weekend before. She'd run away. That's why Officer Hang went to her mother, went to the mother of Isaiah and had her call the school. They're looking for her. They know she's a runaway. So, I put to you that the state has not met its heavy burden in this case. They have not shown you proof of intent. And intent is what matters. Okay? Intent is the key. Look back through the evidence. What was the intent? Where did they show you anything in the evidence that you can say factually, there it is? They can't. They can say, oh, well, all of this bad stuff happened, which indicates intent. No, that's not it. We say, if it happened accidentally, then clearly it's not a crime. It's not intent. You can't say, oh, well, somebody was injured, so they must have intended it. It's like your basketball guy. He made the basket, he must have intended it. No, he didn't intend it. It was wrong, it was a mistake. Bad things happen without crimes being committed. So remember now, Mr. Leary's going to have an opportunity to talk to you. He's going to talk to you a lot more about what happened after. But at this point, Mr. Ali has not been shown to have committed these crimes. I'm going to ask you to find not guilty of everything. If you do decide to go through on the lesser includeds, do it carefully, okay? Just because you say, well, maybe it wasn't in assault 1, it must have been in assault 2. No. Intent is still required. Number 3, was there an assault 4? Take a look at it carefully. Did he intend it? Intent goes to all of them. Okay, totally forgot about unlawful imprisonment. I'm going to go back now, sorry. Unlawful imprisonment. Again, you have the ability to control your daughter, right? She's a runaway. He grabs her by the shoulder. That's not unlawful imprisonment. He hangs on to her. That's not unlawful imprisonment. Okay? What's he doing? He's trying to get his daughter into his car so he can take her home. That's it. That's not unlawful imprisonment at all. If it is, a lot of people in trouble. All right? I am going to leave it at that point and let you hear from Mr. Leary. Thank you very much.
Thank you.
Thank you, Arnie.
Members of the jury, we're actually going to take a 10-minute recess at this time, and then when you come back, Mr. Leary will make his closing argument. Again, we are not done with this process. Do not discuss anything during this 10-minute recess, research anything, and the like. Thank you. We'll be in recess for 10 minutes. Thank you.
All right. Yeah, I see what you got. I see you, chat. I see. Ooh. Yeah, I'm the same way. That was well, we always say they have a job to do. Everybody deserves a defense. So, are you buying Mr. Keating's theory? 69% of you thought this is a load of. 24% of you said it's really a stretch. 4% said it's really good and I'm impressed. 2% said it's brilliant.
I'm going to take a 10-minute.
Just want to see how my audio is. All right. So let's get to his defense. Pretty much the same as what his opening was. Look at the video. Don't trust the witnesses. Trust your own eyes. Isaiah inserted himself. That was basically his opening. Same thing with his closing. So he gets up and he says, I see this differently. 53 seconds is all we need to talk about. How did we get to those 53 seconds? There's two distinct groups. One, there's Ali, the Alis, right? And then the other one is Fatima's friends outside of the family. So he and, Isaiah and her were dating, Fatima and Isaiah were dating for about 10 months. Fatima hid that from the family. We heard that they were sneaking around, meeting, at the park outside of, anybody knowing. So why does she want to run away? Because she doesn't want to go to Iraq. She tells Isaiah she's running away. No one from school calls to tell the parents that their daughter is safe, and they leave them in the dark all day. That could be something there. There could be something of like, why didn't the school call? They could have said, hey, your daughter's here. She's safe. We called law enforcement. We called CPS. Don't worry about her. She's safe. They could have done that. That is one thing I think maybe could have been done, at least just to let them know, hey, your daughter came here. She's expressing some concerns. She wants a safe space. We're giving her a safe space. We've called law enforcement. Don't worry, everything's okay. They could have done that. I'll give him that. He talks about Nora. Nora's the other daughter. Then Miss Robinson was arranging shelter. There was no imminent danger. Fatima tells her that she doesn't